All right, Mr. Askew, good morning, sir.
Good morning.
Ms. Wood tells me you are ready to enter a plea in your case.
Yes, sir.
Okay, well, your position 17 on our trial calendar. It's 22 SC 183736. In a moment, Ms. Willingham will put you under oath. You'll need to answer her questions and mine, and I will do my best to answer any questions you have, and I encourage you to ask them. If something confuses you or surprises you, let Ms. Wood or me know. Will you do that?
Yes, sir.
Great. Ms. Willingham?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Please state your name, your age, and your date of birth.
Kenny Demetrius Askew, 7/23/67. I'm 55 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I got a college degree, associate's degree.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The recommendation in this case, as to counts 1 and 2, the state would null prize, and as to count 3, 4 years to serve 6 months, you are to have no contact with the victim, complete family violence intervention program, complete a substance evaluation, and follow any recommendations that come from that. Is this what was explained to you?
Yes.
You are pleading guilty today to battery family violence with a minimum of 1 year and a maximum of 5 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
The negotiation in this case is 4 years probation to serve 6 years. I'm sorry, it's 4 years to serve 6 years with the balance probated.
6 months.
I'm sorry, 6 months. Yes, Your Honor.
Okay.
That is correct. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 5 years?
Yeah.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, I understand.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence intervention program, complete a substance abuse evaluation, and follow any recommendations. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, not right now. No.
Have you understood everything I've asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. This is a felony offense, so you will have 4 years from the date the sentence is entered. Do you understand these time limits?
Yes.
If this case were to proceed to trial, the state would prove beyond a reasonable doubt that Ms. Tashika Freeman on September 20th of 2020 reported that an incident occurred on September 19th of 2020. She stated that her and the defendant got into an argument after they had a yard sale. She then stated that Askew went to sleep, and when he woke up on September 20th, all of his bags were packed. And I'm sorry, I'm going to start that over, Your Honor.
Okay.
This incident occurred on September 19th. It was reported on September 20th. Ms. Freeman went to the hospital, and she spoke with officers at the hospital as well as at her home after she returned, because her sister also called law enforcement. So they reported to her house, but she spoke with whoever the officer was at the hospital that day. And while at the hospital, she informed officers that the night before, her and the defendant got into an altercation after a yard sale. She stated that both parties were intoxicated. She stated that the defendant beat her half to death. She stated this happened by him choking her, and subsequently he was squeezing her neck with both his hands. He pushed her into the floor and put her in a chokehold and began strangling her by using force of his forearm and bicep. He then flipped her over while still in the chokehold and continued to choke her. She told officers she could not breathe. Throughout the strangulation, the defendant was over Ms. Freeman and placed his knee on her hip and put all of his weight on it. This is where, Your Honor, this is part of the reason that the state ultimately made the offer we made. Ms. Freeman states that she had a hematoma on her hip. However, the police report that we obtained from the officer at the hospital states that the hospital released her because she had no injuries. However, the officer who was at her home, in his police report, it does state there was a hematoma. Ms. Freeman did have scratches and bruises. So the state does believe that we could prove the battery family violence in this, and it is a subsequent conviction, but we were not certain, as the medical records will not reflect that hematoma. And for that reason, the state has made this offer. We have spoken with Ms. Freeman about this multiple times. Her biggest concern was just that the defendant stay away from her. Nothing further from the state.
Okay. Just looking something up. All right.
I didn't read the other.
Ms. Jackson, can you share with me criminal history information for Mr. Askew, please?
Yes, Your Honor. He has 38 cycles. The last arrest was October the 20th, 2020 in Gwinnett County for a probation violation. He does appear to have an outstanding hold out of Riverdale, Georgia for a failure to appear. The underlying charge is not listed. The date on the warrant is September the 20th, 2022. He does have prior felony convictions. This one in 2012 out of Gwinnett County for felony theft by shoplifting. One in 2006 out of Cherokee County for felony theft by shoplifting. And one in 2000, I apologize, let me go back to that, convicted in 2006 out of Cherokee County. It was also a felony obstruction. And there was one in 2001 for theft by shoplifting. And one in 1996 out of DeKalb County for theft by shoplifting. And one in 1994 out of DeKalb County for obstruction of an officer. And one in 1987 out of DeKalb County for possession of a firearm during commission of a felony. He does have misdemeanor convictions and sentences. This one in 2013 out of Cobb County for driving while license suspended or revoked and obstruction of an officer. And he received a nolo contendere sentence in 2012 out of Forsyth County for driving while license suspended or revoked. And there was one in 2012 out of Gwinnett County for battery, family violence. And there was one in 2005 for DeKalb County for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Wood.
Thank you, Judge. Mr. Askew is 55 years old. He has been in custody 195 days, so since November 25th of last year. He does have his GED. He does have an associate's degree, as he said. He is an Army veteran. He served and was honorably discharged. He's previously worked in the restaurant industry, and he was also employed as an outreach specialist. And he may want to tell you more about that on his own. He was doing that for 6 months prior to being locked up for this. I do believe, and he's told me, alcohol was a factor for both parties for this incident. He's telling me that he has been sober for the past year. So we are hopeful that this is the last time that I see him in a jumpsuit, Judge. He has family in DeKalb County. They're going to help him get stable and on his feet. So we would just ask that you accept the state's recommendation in this case. Oh, and one last thing. He wanted me to ask you to consider setting a behavioral incentive date. And I have talked to ADA Willingham. She doesn't have any issue with that request as well.
Okay. Ms. Willingham, you mentioned you had spoken with Ms. Freeman a number of times. I don't recall you having as a condition of probation, no contact. What was Ms. Freeman's view about Mr. Askew ever again being in her orbit?
And I'm sorry, Your Honor, I thought I did ask.
Maybe you did and maybe I missed it. No contact?
I would ask for no contact.
Okay. Got it. Mr. Askew, I've got a couple questions for you and then you can add anything you want.
Yes, sir.
Ms. Freeman and you were clearly spending time together back in 2020. That's a while ago.
Right.
Is she out of your life? And more importantly, are you out of her life?
Yes, sir.
You'll be able to.
I haven't had contact with Ms. Freeman since the beginning of had to be the beginning of 2020. I mean, the 2021.
2021, because clearly you were with her in September of 20. That's when this happened.
Beginning of that, I haven't had any contact.
Okay, good. It'll stay that way. Tell me what an outreach specialist is.
Outreach specialist, I work in the English Avenue, I guess you call it the Bluff area. So I'm pretty sure you heard of that. We do outreach to all the people out there, the people on the drugs. The people who own heroin, who do the drugs, we change the needles so they won't be giving out HIV, that type of stuff. I was in charge of getting all the people mail in, having them get their food stamp cards. I was in charge of donating clothes and issuing out meals. And the person who worked with me, she was the one who would get in the computer and help them with other different type of services.
What was the organization you worked with?
Atlanta Harm Reduction Coalition. Now it's the Georgia Harm Reduction Coalition.
Great. Did you get paid for that or was that volunteer?
No, I volunteered at first when I was getting sober, and then they hired me, even with all my past, and I was excelling in that job. So kind of this past thing kind of messed me up with. I hope I can get my job back.
I hope so too. That's real important work. And you are probably good at it in part because of your past. You say they hired you in spite of your past. They may have hired you because of your past, because you can relate a whole lot better than someone coming in from the outside. Like, oh my God, what are you doing with the needle? I mean, not that you use needles, but you understand much more the dynamic of life in the Bluff than someone coming down from Johns Creek. So, okay. All right. Anything else you want to add?
Well, the 4 years probation, I was hoping that it'd be 2 years probation.
So it's already only 3.5 because the 6 months that you served come out of that. So it's already 3.5. And I will set a behavioral incentive date in a little bit.
Okay.
If you had a slightly smaller criminal history, I might be inclined to just say it's less probation, but you are now at an age where I think you have gotten out of your system most of your dumb ideas, and hopefully all of your felony convictions, except for this one. But we need to make sure.
Okay.
Ms. Willingham, do you know if the victim in the family violence conviction out of Gwinnett was also Ms. Freeman, or if that's a different
In my communications with Ms. Freeman, it is not.
Okay.
I didn't even know her then. That's Latoya Dickinson.
Okay. Different victim. All right. We'll stay away from her too.
Yes.
All right. Mr. Askew, do you authorize my team to sign the indictment indicating your guilty plea to count 3?
Yes.
Ms. Wood?
Yes, Judge.
Ms. Willingham?
Yes, Your Honor.
All right, we'll do that. Mr. Askew, I find there's a factual basis for your plea to family violence battery. You and Ms. Freeman got into it that night or day, whenever it was. I don't have Ms. Freeman in front of me. My guess is you're bigger and stronger and you need to handle those situations in a different way, whether it's a walk away or a talk it down. But it's never okay to lay hands on someone like that. And I'm not saying Ms. Freeman wasn't doing the same to you. That's not the point here. You need to handle it differently. But I do find there's a factual basis for the plea and that your plea is knowing and voluntary. Voluntary means you're moving forward on this of your own free will. No one's forcing you to do that. Is that correct?
Yes, sir.
And a knowing plea just means you've understood everything. Do you have questions about anything anyone has said?
No.
No? Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation for however long you'll be on, if you have a small or technical violation, probation will work through that with you. I don't have to get involved.
Okay.
More importantly, you don't have to come to court.
Okay.
If it's more serious, you get arrested again, you're doing something to Ms. Freeman, then that comes back to me.
Yes, sir.
And I will sentence you to 4 years to serve 6 months. You'll get credit for all the time you've been in, which is actually more than 6 months. So you ought to be released today or tomorrow.
Okay.
The balance will be on probation, which is 3.5 years of probation. I will set a behavioral incentive date of June 8th, 2025. That's 2 years from now.
Okay.
If everything is going well, you've made probation happy, you've been easy to find, you've done what you need to do, you're working, you're out of trouble, they will be authorized to say, let's just close this all out.
Okay.
So be good for 2 years. Let me finish, and I'll take any question you want. Special condition of probation number 1, you're going to complete a family violence intervention program, which is a series of classes to help you think through things in a way differently than you did back in September of 2020. In conjunction with that, and you may not need it, which is, well, you may not need part 2, you're going to submit to a drug and alcohol abuse evaluation where an expert will talk with you about what you smoke and drink and whatnot. And if that person recommends any treatment, that treatment will become part of your probation.
Okay.
And finally, no contact with Ms. Freeman. Don't call her, don't write her. If you know where she hangs out, don't go around there. Okay?
Yes, sir.
You look like you had something you wanted to ask.
Yeah, I think you pretty much. Oh, yes, it's a foreign hold on me. I've been writing Clayton County. It's not me, it's my brother who got caught with an open container. I have written them when I was at the Atlanta Harm Coalition. I would email them on the phone, try to let them know that that wasn't me. They suspended my license. I'm trying to figure out if there's any kind of way I could contact them. I don't know if they're coming to pick me up for that charge.
Right. So one of two things will happen. Either they're going to drop that detainer because they're going to get a call. I think it's Riverdale.
Yes.
They're going to get a call today or tomorrow saying Fulton County is now done with Mr. Askew. You need to come get him.
Mhm.
And they can say, never mind, drop the detainer. Or they're going to come get you. And then you will be in front of the right person, which will be a magistrate or a municipal judge in Riverdale. And they'll say, wait a minute, that's not you. And you need to fuss at your brother if he used your name.
I already did.
Okay, good. Don't do something that gets you arrested again. Just fuss at him from a distance. Family violence intervention
Yes,
program.
yes, sir.
All right. Anything else, Ms. Willingham?
Nothing further.
Ms. Wood?
No, Your Honor.
All right. Before you go, because I'm learning, Ms. Tucson, can you engage Mr. Askew, please, about probation and reporting?
No problem. Is my audio better?
I think so. Yep. We don't hear ourselves 3 times. So you're perfect. Good job.
Okay. Mr. Askew, do you know where Fulton County probation is?
No,
Okay. What city are you going to be living in?
I will probably be in DeKalb County, probably in Latonia.
Okay, if you live in Lithonia, I will need to get that address from you, and I will have to give you the address there to report, okay? Because their address, for DeKalb County, it's actually in, Conyers.
But here's the thing, man. I'm not sure exactly. Once I get out, I was told by my family they're gonna get with me and find me a place, get me a place for about a couple of months till I get back to working. So,
Well, we need to know where you're gonna be laying your head to rest for the first few weeks.
oh, that's at my mom's
Okay,
house.
you can always move. You just need to let probation
Right.
know.
Yeah, okay, I understand. Okay, you need that address now?
I do need the
Oh,
address.
okay. It's 2512 Hillvale. That's Hillvale Circle, Lithonia 30058.
HILLVALIS.
Yeah, no, HILLVALE Circle.
Okay, and the numerical portion again?
Oh, it's 2512.
Okay, just wanted to confirm that. And do you have a phone number we can put on file?
Yes, 678
Mm-hmm.
418 0919.
Okay, you're gonna need to report on June 22nd,
Okay.
and let me know when you're ready for the address.
Ready.
And that one is, and you said Covington. Okay, so this is for DeKalb. Lithonia's in DeKalb, right? Stone Mountain. 981 East Freeway Drive, Southeast, Conyers, Georgia, 30094.
What's it, Conyers?
Yes.
No bus at the.
It's where family will help out.
Okay.
All right, June 22nd.
Okay, I need to ask her a question.
Okay.
Miss Tucson?
No problem, I'm here.
Okay, now, what if these people from Clayton County come pick me up on this open container and I'm detained there for a little while that runs into this June 22nd? I don't want to get a violation when I'm still in jail. I have a foreign hold, which I don't know whether it's a misdemeanor, open container, which is not even me, but I had to prove that once I get there, and I don't know whether they're coming to pick me up or not. I don't know how long it's going to take me to dispose of that case, even though I have an affidavit.
Well,
Have a-
since your disposition is today and that's an older matter, you would once you do report to probation, you would let them know that, and they will confirm with the date, so that way it won't violate you.
No, I'm saying, so what if I'm still there on June 20 when I'm supposed to?
Right. Mr. Askew may not get released right away. He's done here, but there's a hold from Riverdale, and Riverdale hypothetically could take a week to get him. And then he's down there for 2 weeks, and all of a sudden his date to report in Conyers has come and gone. And he understandably doesn't want a warrant for that because he would have been stuck in custody. In other words, he may not be a free man then.
Okay, gotcha. I will put that in the case notes, so that way when the officer who is assigned gets his case, he or she will read my intake note.
Great.
Awesome.
Sounds good. Thank you, Ms. Tucson.
Thank you,
No
Judge.
problem.
Thank you.
You bet.
So I wrote it down for you, okay?
All right. Thank you very much.
You're welcome.
All right, what do we want to, let's do one more. I need to go make a phone call, but before I make that phone call, what are we going to do next?
Yeah, I could do Hopkins or Mr. Bateman. Mr. Bateman, if that's okay. He's position 22.
Who's the guy in the red shirt?
Bateman's father.
Oh, okay. So let's do Bateman. I saw Mr. Adams here briefly.
Judge, he went to another court, but we're ready at the court's pleasure to take a plea on it.
Okay, that may be after lunch. If we're going to do Bateman now, But we'll talk. So I'm gonna go make this quick phone call and then we'll do Bateman, and then we'll take everyone's pulse.
Please ready to go and walk. If Bateman and then everyone else are ready on Carlos.
Talk to him.
Yeah.
Oh, this is John. It's gonna give us a misdemeanor.
Perfect. Great work. Yeah, I'm gonna go to the bathroom while I can.
Sorry. He's falling off, but I think that's my shoulder.
Take lunches in here. Yeah.
Since I know the mics are hot, some courtrooms roll until 10 o'clock at night.
That's right. We won't say which one.
You don't know. Never again.
No.
Prayerfully.
Except for me, I mean, that's gonna be a month. But at least we're on the nose about it, so it's not.
That's true. Some days I want to go to the movies like that. Was in court. Sorry.
So right, take it together. Guardians and guardians together.
Right. Go, that's when you go pay in cash. I'm gonna take this one, or is it a little short or something? This is kind of what it is.
No, we'll take it.
That's all. Sending the final please. I know it's tomorrow, but still, I got as long as I got.
That's all we get back.
Right. For this one's the dead body is the same as the predecessor, which was the 5-2.
The family had that.
But I said it's and like I said, just but it's the same as the code. All right.
Did the defense attorneys go back into lockup or
Just Ms.
whoever was going to do Bateman? We can.
I'm one defense attorney, Your Honor.
Judge, typically I don't do this because the defendant's standing there, but my computer is running low. Can I sit here?
Sure. Yeah, as long as that microphone is picking you up, maybe we'll have Mr. Bateman stay seated
Okay.
because then he's looking across rather than going
Okay.
to look back.
Well, Your Honor, if they're not ready, I mean, we're ready for a plea. If.
I'm ready. So if we should do O'Neill, let's do O'Neill.
Okay. Well, tell me if they're not prepared.
Well, Mr. Bateman's father's seems, let's just bring someone out.
I'm sorry.
Okay, we ready on Bateman?
We are, and actually the sheriff said it might be helpful if we made the announcement on Dill first, so you can be excused.
Okay. If we just bring the announcement is we'll see him on Monday. Okay, if we can bring Mr. Dill to the door and then Bateman out right after we're done with Dill.
Yeah, we'll pick a jury Monday. Be done Tuesday. I need to actually go.
Hey, Mr. Dill, how you doing? I just want to give you an update. You are likely first out for trial on Monday. I've been talking with your lawyer, Ms. Feely, as well as the prosecutor, Ms. Willingham, and they've been giving me updates. There are a couple motions that we'll need to talk about with you in the room, but we do that Monday, and then we picked a jury. But that's where we are. So I didn't want to keep you waiting around. It doesn't sound like it's a case that's going to work out, given what I've been told the state's offer is. So I understand why you're ready for trial, and that's what we will likely do come Monday. Okay, Ms. Feely, any instructions to Mr. Dill, or you'll see him soon?
In the process of arranging to get his clothes from his mom, so I think we'll be ready.
Fantastic. Yeah, you will not need to wear the red jumpsuit for trial. Okay, I'll see you Monday. All right, Mr. Bateman, please. And this is position 22. And what we're going to do, if it's all right, is do that from the table. Ms. Willingham's computer is fading, and so she can't be up here. And that way, Mr. Bateman can look across if he's looking at her rather than look backwards.
Speaking to the mic.
All right, Ms. Rivers, you ready?
Yes, I am.
Great. This is position 22 SC 185167, State versus Myron Bateman. Good morning, Mr. Bateman.
Good morning, sir. How you doing?
I'm doing okay. How are you doing?
I'm doing all right, sir.
Good. Mr. Bateman, Ms. Feely tells me that you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Ms. Willingham, the prosecutor, who's way at the end of that table, is going to swear you in. Once you're under oath, you'll need to answer her questions and mine. And I am here to answer any questions you have, unless you want to ask your lawyer. But please do ask questions if you've got any, okay?
Yes, sir.
All right, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your name, your age, and your date of birth.
Myra Eugene Bateman, date of birth 6/20/1986. I am 36 years old.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
10th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The recommendation in this case, as to counts 1, 4, and 5, is 5 years to serve 2 years. As to count 9, 5 years suspended, and as to count 13, 5 years to serve 2 years. And those are to, with the exception of count 9, all those counts are to run concurrent, and any remaining counts on the indictment will be null pros.
Can you give me those counts again? So 1,
4, 5, and 13
Yep.
are all 5 years to serve 2 years, and they
Yep.
will run concurrent. Count 9 is 5 years suspended.
and that's consecutive.
Yes,
Got it.
and all other counts will be null pros.
Okay.
You are pleading guilty today to aggravated assault strangulation with a minimum of 3 years and a maximum of 20 years. Aggravated assault family violence with a minimum of 3 years and a maximum of 20 years. And aggravated assault with a deadly weapon with a minimum of 1 year and a maximum of 20 years. Possession of a firearm during the commission of a felony with a mandatory 5-year consecutive sentence, and possession of a firearm by a convicted felon with a minimum of 5 years. Are you now serving, I'm sorry, is that what was explained to you by your attorney?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court what the negotiation is in this case, which is a total of 10 years to serve 2 years. 5 of those years are suspended. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence by law, which is 70 years?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no violent contact with the victim, complete family violence intervention program, and no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
Any other questions?
That's it.
So the record should reflect that Mr. Bateman did have a question or two for Ms. Feely, and they conferred. And Mr. Bateman saying he's ready to keep going?
Yes, I'm ready to keep going.
Perfect. And that was the right way to do it. If you've got questions, do it just like that. Thank you.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Your Honor, one moment. I'm going to switch over to the facts. If this case were to proceed to trial, the state would prove beyond a reasonable doubt that on May 7th, 2021, Officer Bruno was dispatched to 178 Maury Avenue, Southeast, apartment 3614, regarding an aggravated assault. Bruno met with caller Shanika Jones on May 7th. On May 10th, 2021, investigator Thomas followed up with Ms. Jones concerning the aggravated assault. At that time, Ms. Jones stated that her ex-boyfriend and the father of one of her children, Myron Bateman, pointed a gun in her face. She said that she told the accused that he could no longer live with her because he was not helping with the expenses. The accused called her earlier that day on the 7th, asking to pick up his TV. She told him he could come get the TV, at which time he came to the apartment and her friend Shavonda Moss let him in. After he gained entry, he pointed the gun at Miss Jones, Miss Moss, and Miracle Drag. Miracle Drag was Miss Jones' niece who lives with her. He pointed a gray 9mm handgun in their faces and made everyone lay face down on the floor. Miss Jones told Officer Bruno that the children were there when the accused first came in, but did not mention the children to Investigator Thomas. While they were there lying on the floor, Mr. Bateman kicked the bedroom door off its frame because it was locked. He did not retrieve the television set and left after a few minutes. Miss Jones stated that he said he was coming back and would shoot them at that time. Miss Jones seemed certain that the children did not hear the threat. Miss Jones stated that Mr. Bateman thought there was another male in the apartment. All 3 ladies were interviewed separately and had similar versions of the incident. On August 19th, 2021, Officer Livingston with several officers were dispatched to a fight in progress with an armed person at the incident location at approximately 5:17 a.m. Officer Livingston met with Miss Jones, who stated that Mr. Bateman had strangled her and stated he was going to shoot her and any police officer who came. His actions caused pain around her neck and difficulty swallowing. Mr. Bateman had 2 guns with him during the incident. When he began loading one of the firearms in front of her, she grabbed her daughter and left the apartment. While the police were on scene, Ms. Jones advised officers that Mr. Bateman was calling her from inside the apartment. An officer asked if he could speak with Mr. Bateman, at which time the officer told Mr. Bateman multiple times to exit the apartment, and he replied he wasn't going to jail and he wasn't coming out. When officers subsequently went into the apartment, no one was found inside, nor were any firearms. Your Honor, the state has spoken with Ms. Jones. The minor child, Miracle Drag, who was in the home at the time, is no longer in Ms. Jones's custody. The state has had difficulty locating her, as Ms. Jones is not cooperative. She's not willing to assist us in locating her, nor is she willing to assist us in locating Ms. Moss, who was her friend at the time. And I actually spoke with Ms. Jones again today after receiving the counteroffer from the defense, and she was okay with that. That was probably the best conversation we've had thus far. But based on that, as well as a few inconsistencies that we saw and being unable to actually speak with Ms. Jones in depth to further proceed with this case, we think this is the best resolution.
Okay, so Ms. Jones is aware of the outcome. You're going to share with me any conditions of probation. Does she want Mr. Bateman to stay away from her? They have a kid together.
She's asking for no violent contact.
Okay. And Miracle Drag is not their shared child.
No, Miracle Drag was Ms. Jones's niece.
Okay. Got it. And Ms. Jones had custody of her niece for a while, doesn't anymore.
Correct.
And isn't telling you who does.
Correct.
Okay. All right. What other conditions did maybe you already said it?
It's okay. No violent contact, complete family violence intervention, and no weapons.
Okay. Got it. Okay. Thank you. Ms. Jackson, can you help me with criminal history, if any, for Mr. Bateman?
He has 23 cycles. The last arrest was September 30th, 2018, with the City of Atlanta Police Department for a failure to appear. He does have prior felony convictions. One in 2010 for theft by receiving stolen property and possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon. There was one in 2008 for possession of cocaine with the intent to distribute. And there was one in 2007 for possession of cocaine with the intent to distribute. And there was one in 2004 for aggravated assault. And there was another one in 2004 for possession of controlled substance with the intent to distribute. He does have prior misdemeanor conviction. One in 2015 out of DeKalb County for battery, family violence. There's another one in 2015 out of DeKalb County for criminal trespassing. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, is Mr. Bateman on Those are all older felony convictions. Is he on active probation now?
He is active on probation now on a case that's getting ready to expire. 17 SC 149096.
Okay, how much time is left on that?
24 days, and
Huh.
he's not in warrant. He's not in warrant status.
Okay, all right. So we can probably just leave that alone. I don't know what the point of revoking that would be. Okay, great. Thank you so much. Ms. Feely?
Thank you, Your Honor. As the court heard, I think this would be a very messy case for the state, one that I think would resolve in Mr. Bateman's favor. However, given the offer, he is asking the court to accept the state's current recommendation for resolution of the case. He's 36 years old. His dad's here in the red shirt. Has been here in support of him for most of his court dates, if not all. He has been in continuous custody since August 23rd of 2021. He never posted bond. He was transferred to DOC, but that was based, of course, on this. And then he's been back with us since August of last year, but he has been in continuous custody, for which he should get credit since August 23rd of 2021. When he gets out, he hopes to spend time with his 3 children. He works at the Speedy Co. on Moreland. He changes oil and tires and that kind of thing. So he knows that he can go back to that job, and he's hopeful to get back on his feet and put this behind him and this relationship as far behind him as he possibly can. So we are asking the court to accept the state's recommendation.
Mr. Bateman, how old is the child that you share with Ms. Jones?
3,
How old are your other kids?
12, and 8.
And are the 12-year-old and 8-year-old, do they share the same mom, or is it 3 different moms?
3 different mom.
Okay. Do you have a way to contact Ms. Jones?
Yes, sir.
How is that?
I call on cell phone, but I don't want to talk to her no more.
Okay, and I don't want you to either. I just want to, you have a right to see, is it a daughter or a son you have with Ms. Jones? Daughter?
Yes, sir.
Okay, I just want to understand how you would try to see your daughter if you were going to do that. And maybe there's a third party you could go through, but I'm not going to say you cannot contact Ms. Jones. It just would need to be limited to things like, hey, I need to see my daughter.
Yes, sir.
Okay. Where are you planning on living when you get out?
I plan on living with my brother for a minute till I get on my feet.
Okay. And what city does your brother live in?
He's staying in Atlanta.
In Atlanta?
Yes, sir.
Okay. Anything you want to add to what we've been talking about?
No, sir.
Is this the longest you've been in
Yes, sir.
for all the different cases we heard about?
Yes, sir.
What makes you think you can go back to this job that you had? Is it friends or family who work there?
Friend, he told me I can always come back because he liked the way how I work. And I let him know what was going on with my situation.
Okay, good. All right. Well, Mr. Bateman, if there's nothing else you want to add, I find there's a factual basis for your plea. Sounds like you and Ms. Jones had a pretty bumpy relationship and things sometimes got out of hand. I also find that your plea is knowing and voluntary. Knowing means you've understood everything. And if you didn't, you asked questions, which you did of Ms. Feely. Do you have any questions for me about anything we've talked about?
No, sir.
All right. And a voluntary plea just means no one's forcing you to enter this plea. You've decided that this is the best way forward for you. Is that correct?
Yes, sir.
All right. I'm sentencing you under the Probation Options Management Act. And all that means is that while you're on probation, which you will be for a few years, if you have a minor violation, you and probation will address that. But if it's more serious, you get arrested for something, then your case will come back to me. Mr. Bateman, do you authorize my team to sign the indictment indicating your guilty plea to the 5 counts to which you're pleading?
Yes, sir.
Ms. Feely
Yes, Your Honor.
and Ms. Willingham?
Yes, Your Honor.
Great. And we'll leave the 17 SC case alone. There's just there's no warrant for you on that, and that probation is going to expire naturally in less than a month. So getting to the charges in this case, I am going to sentence you on counts 1, 4, 5, and 13 to 2 years to serve. You'll get credit for all the time you've been in, which sounds like is from August 23rd of 2021. So you're getting pretty close to being done. Then for count 9, which has to run consecutive, I'm giving you 5 years probation. So the sentence I'm giving you is a little different from what you've been hearing about. The part you're probably most focused on is the same, 2 years to serve with credit for time served, but is followed by 5 years probation, not some probation and some suspended. Then your sentence will be done. Special condition of probation number 1 is no violent contact with Shanika Jones. You may have no contact. That's fine. That's not violent contact. But if you do reach out to her because you want to see your daughter, it can't be anything like what I was hearing about today. Second condition is that you complete a family violence intervention program, which is a set of courses that you'll go to over the first few months after you get out. I will waive your probation supervision fees for the first couple months after you get out so you can get settled, situated, and working again. Were there any other conditions you wanted to see imposed, Ms. Willingham?
No, Your Honor.
Ms. Feely, anything else?
No, Your Honor.
Mr. Bateman, Ms. Tucson, who is with the Department of Community Supervision, which is probation, she's going to ask you a few questions about where you're going to be living. I know you said just initially you'll be at your brother's, but we need that initial address because that drives where you start reporting to probation. And then when you move, you just let probation know that you moved, okay? Any
Yes, sir.
questions?
No, sir.
Okay, Ms. Tucson?
All right, thank you. I'm going to read an address, Mr. Bateman, and you could tell me if this is accurate. Is it 942 Hank Aaron Drive?
Yes, sir. Yes, ma'am.
Is that where you will be living when you're released?
Yes, ma'am.
Okay, and can you confirm a phone number, a good phone number for you?
44
Mm-hmm.
587
587.
5159.
Okay, you're gonna need to, so that way this docket is uploaded, you're gonna need to report June 22nd and all the case notes will be in. And you know where, Fulton County is, correct?
Yes.
Okay, and do you have your officer's phone number?
Now.
Officer Gresham, do you have her number?
No, ma'am.
Okay, I'm gonna give you her phone number, okay?
Thank you, ma'am.
470
Uh-huh.
322
Uh-huh.
7272.
Copy.
You're good. Keep talking. I'm done. I'm just letting you two have your final conversation.
I might have to have 2 more minutes. They say I got to report June 27th.
Mr. Bateman is concerned. He's hopeful that he will get out before, but
This is the ask you problem. So, Ms. Tucson, Mr. Bateman's 2 years may not be up by June 22. The sheriff may release him early, but the sheriff's not required to do that. And the 2 years really don't run until August, late August. So what do we do with that June 22 date you set for Mr. Bateman?
Well, I can change the date to 48 hours after release. His probation case will close out in 24 days anyways on July 1st. So if he's there until August, he'll just be reporting, but the case notes will still be in his file since, you know, he has an active GDC number.
So let's do that. Let's do report within 48 hours of release and handle it that way.
Okay, I will put that in the case notes and just make sure you report there, Mr. Bateman, and you don't have to call Officer Gresham.
Yes, ma'am.
Okay. Thanks, everyone. So I can do Mr. O'Neill, if we can pull that off. If you are here for a different case, we will reconvene at 1:30 if you want to go get lunch. But we'll do Mr. O'Neill and then we got a break. Mr. Hiles, you are here for?
Ms. Riley, may I approach?
Yeah.
Thank you, John.
You bet.
Thank you, paper copy. Kind of weird how we had to do it in Odyssey.
Yeah, I wasn't sure what you saw my order revoking the bond.
And so they wouldn't, she tried to turn herself in.
Oh, really? Oh, I'm glad she did.
And so they will.
I have to come up.
Warrant, and then we're gonna have to. You can talk on future cases, because I'm more excited about how quickly a hearing needs to happen, regardless of anyone filing.
We should have a hearing. I agree. But I want her off the street and then we can talk about it. Yeah. So I don't know if Kelleher wants to reach out to Ms. Nelson, or you can, but we can get her brought over whenever.
Yeah, I'm walking this over and make a copy of this, and then take it to the sheriff's office so they can upload it to GCIC.
Okay.
Have email to all parties who say that this should be active.
And then she can turn herself in. Okay, good. All right, you bet. $370,000 bond.
It was, I'm very upset because there was a bunch of allegations, and it wasn't Kelleher representing her.
No.
But there was a bunch of allegations made to that particular judge.
Ms. Nelson told me that this is over with and you love her and she's testified. It's all, I mean, yeah, that was a problem.
Yeah.
1 second.
Can you take that on?
Damage to the home. We pay that off probation.
So we have position 5, Anthony O'Neill, 19 SC 172809. Hello, Mr. O'Neill.
Hey, how you doing today, sir?
I'm all right. Good to see you again. Mr. O'Neill, Mr. Wright tells me that you are ready to enter a plea in your case. Is that correct?
Yes, sir.
Mr. Adams was here. He's been in and out. He, like Mr. Wright, is popular and wanted in a bunch of courtrooms. He may pop back in while we're doing this. Are you okay going forward with Mr. Wright by your side?
Yes, sir.
Okay, I am too. And Mr. Jordan, you'll be handling it for the state?
Yes, Your Honor.
Okay, Mr. O'Neill, in a moment, Mr. Jordan's going to put you under oath. Once you're under oath, you'll need to answer all his questions and mine. If at any time you want to talk with Mr. Wright, you've got a question for me, let me know. If it's something you two need to talk about in private, we'll get you right back there. But I won't know that you've got a question unless you either poke at Mr. Wright or let me know, okay? Yes,
sir.
great. All right, let's go.
Thank you. Mr. O'Neill, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth? Yes, sir. Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Anthony D. Quavies O'Neill.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 28 and I went to the 11th grade.
Okay. And did you complete the 11th grade?
No.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses? Counts 1 and 2 being armed robbery, count 3 being hijacking, counts 4 and 5 being aggravated assault, count 6 being possession of firearm during commission of a felony, count 7 being reckless conduct, count 8 hit and run resulting in serious injury or death. Count 9 being discharge of a firearm near a public highway. Count 10 being failure to obey a traffic signal. And finally, count 12, possession of firearm by a convicted felon.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your lawyer, Attorney Wright, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes.
Mr. Wright, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Mr. O'Neill's name?
So waived.
Mr. O'Neill, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Wright, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. O'Neill, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes, sir.
Okay, and Your Honor, just for the record, the state is moving to dismiss counts 2 and 3, which is 1 count of armed robbery, 1 count of hijacking. Count 11 does not apply to Mr. O'Neill, as it was only for his former co-defendant, Mr. Palmer. For armed robbery, the minimum is 10 years and the maximum is 20 years. For aggravated assault, the minimum is 1 year and the maximum is 20 years. For possession of firearm during commission of a felony, that is 5 years to run consecutive. For reckless conduct, it is 12 months maximum and a minimum of 1 day. For the hit and run charge, that is a minimum of 1 year and a maximum of 5 years. For the discharge of firearm and failure to obey traffic signal, those are misdemeanors, so there will be 1 day and a maximum of 12 months. And finally, for possession of firearm by a convicted felon, the minimum is 1 year and the maximum is 10 years. Mr. O'Neill, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, this is a negotiated recommendation. The state's total sentence would reflect 17 to serve 5, and I can give you the breakdown on that. For count 1, the state's recommendation is 12 to serve 5, with the balance being probated. We would ask that Mr. O'Neill have no contact with the victims listed in the indictment. Also, one of the special conditions of probation, Your Honor, would be restitution to be paid in the amount of $7,889.45. That has been requested by the Utica, and that's UTICA National Insurance Group. They actually, Your Honor, were the insured for the van, which was, I believe, destroyed as a result of the accident that occurred after the armed robbery. And I have an address to send that to. Would you prefer for me to put that on the record, Your Honor, or would you like me to just send that to Ms. Nelson?
The latter.
Yes, Your Honor. For count 2 and count 3, as previously stated, the state is recommending to dismiss those counts. For count 4, the state's recommendation is 5 years to serve to run concurrent with count 1. That would be the same recommendation for count 5, which is also aggravated assault. 5 years to serve to run concurrent with count 1. For count 6, possession of firearm during commission of a felony, the state's recommendation is 5 years probation to run consecutive to count 1. For count 7, reckless conduct, the state's recommendation is 12 months to serve. For the hit and run felony charge, the state's recommendation is 5 years to serve to run concurrent with count 1. For count 9, the discharge of firearm, the state's recommendation is 12 months to serve to run concurrent with count 1. For count 10, the failure to obey traffic signal, the state's recommendation is also 12 months to serve to run concurrent with count 1. And finally, for count 12, the state's recommendation is 5 years to serve to run concurrent with count 1. Mr. O'Neill, was that the negotiated recommendation that was communicated to you?
Yes, sir.
And I apologize, Your Honor. We are asking that you accept this downward deviation under, I believe, 17-10, 6.1E, Your Honor. Do you understand, Mr. O'Neill, that the court does not have to accept that recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you currently on probation or parole?
Probation.
Okay. Do you understand that since you are currently on probation, your probation may be revoked based on you entering a guilty plea today?
Well, that thought. Didn't you already go into state custody because of a probation revocation because of these charges?
Yes, I'm done with it.
Right, because you're not wearing red anymore, but I know the number on this calendar that says you've been in jail for 714 days. I think it's longer than that because I think you went to the Department of Corrections because you got revoked. How many? Well, we'll find out from probation, but I didn't want you to think, wait, I could be revoked again. If you have not, I'm making this up, but if you're on probation for 3 cases and you got revoked on 2 of them for these charges, you cannot be revoked again. That's happened. But if you had a case in DeKalb County and you never got revoked on that, this conviction could cause DeKalb County to say, come on over here. Look at this. You pled guilty to armed robbery. We're revoking 3 years or whatever it is. So you understand, if you have any open probation cases for which you have not been revoked, a consequence of today's plea could be a revocation. Does that make sense?
Even though I haven't been out.
Well,
Here's a question. Other than what the court has described to you, you went on the case you were on probation for. You were revoked and have come back, correct? Do you have any other probations?
No.
that's a better question. So you were only on probation for 1 case.
Yes, sir.
Okay, you've already been revoked for this. So what Mr. Jordan said is typically correct. Hey, this guilty plea could cause you to get revoked because usually things don't move as slowly as this case has moved and as quickly as that revocation has worked out. But you won't be revoked a second time for this.
All right.
Okay.
My apologies, Your Honor. Attorney Wright did explain that to me earlier. I do apologize about that. Mr. O'Neill, do you understand that you're being placed on probation as part of the state's recommendation that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yeah.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of the guilty plea, as this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
And Your Honor, since this is past final plea, you would not allow Mr. O'Neill to withdraw his plea after today, is that correct?
That's correct. So Mr. O'Neill, Mr. Jordan already touched on this. I've already had a conversation with your lawyers. They came back to talk to me about some of the concerns you've got, how it's been in custody, et cetera, which was important for me to hear. And they shared with me where they're thinking of going with a recommendation. That does not bind me. I'm not part of those discussions. As Mr. Jordan mentioned, I could sentence you to 20 years on the armed robbery if I think that that is the right outcome. You should have a pretty good idea of what I think reasonable outcomes are because your co-defendant did not get 20 years. He got 12 to do 7. So that's a pretty serious marker out there. But I want you to understand that I will listen real carefully to what Mr. Wright has to say and what Mr. Jordan has to say, and they will be persuasive. they're going to tell me I should sentence you to 17 years to serve 5 with a whole bunch of probation. I might sentence you to 17 years to serve 6. You're stuck with that. You don't get to say, wait, whoa, I was going to take 5. I want to go to trial on Monday. You're going to get whatever sentence I give you as influenced by these 2 lawyers. And you don't get to back out of it if it's different from what Mr. Wright and Mr. Jordan are telling me. Do you understand that?
Yes, sir.
And you ready to go forward?
Yes, sir.
Let's do it.
Mr. O'Neill, do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
And Attorney Wright, did Mr. O'Neill intend to enter this plea under North Carolina v. Alfred?
Yes, my client is tendering this plea because he believes it's in his best interest to do so, and would tender this plea under the authority of North Carolina versus Alfred.
Thank you. Mr. O'Neill, are you pleading guilty under North Carolina v. Alfred because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Mr. O'Neill, how do you plead to the charges of armed robbery, 2 counts of aggravated assault, possession of firearm during commission of a felony, reckless conduct, hit and run resulting in serious injury or death, discharge of firearms near a public highway or street, failure to obey traffic control device, and possession of firearm by a convicted felon, in indictment number 19 SC 172809?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that for the felony charges, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And do you understand for the misdemeanor charges, you have only 12 months to file that same petition?
Yes, sir.
Thank you. And Your Honor, for a factual basis regarding this plea, on October 12th of 2019, an officer from the Atlanta Police Department was dispatched to the intersection of Fulton Street Southeast at the I-75 and 85 northbound entrance ramp, which is within Fulton County, on a vehicle accident with injury call. Upon arrival, the officer stated that he could see a Smith & Wesson SD9 V8 handgun that was laying on the ground near the accident. During that time, he could also see a black male a little further down the street across the scene of the accident, limping on one leg, then finally dropping on the ground as he was laying there. The officer was also met by a Grady unit who was working on a family of 4 who had been involved in the accident. A small child could be seen on the ground, unable to move due to pain throughout his body. There was also a male in the passenger seat of the Ford Econoline van with a Georgia license plate that at that time was unconscious. The male was also being cared for by Atlanta firefighters and also Grady units. Your Honor, the officers spoke to multiple witnesses whom stated that they saw the accident occur. The first witness was Mr. Christopher House. Both of those have normal spelling, whom stated that he was behind a witness who also spoke to officers when he saw the Ford van driving recklessly. Mr. House stated that the vehicle went around as he was trying to run the red light, and that's when he struck the second vehicle head on. The second witness, Miss Justina Dix, Justina spelled Justina, last name Dix, Dix, whom essentially stated the same thing. She did state that the driver of the van hit the second vehicle so hard that she believed that the passengers were dead. The passengers to the vehicle did sustain injuries. The most severe was a Miss, I believe it's pronounced Marilu, Marilu, last name Castano, Castano. She did, we have her medical records, Your Honor. I believe she suffered a injury to her hip.
No one died in that car.
That's correct, Your Honor.
And the little kid who was on the ground when the officer showed up ended up being okay.
Yes, Your Honor. The officer whom initially responded to the traffic accident then went to the hospital where he met with investigator Maldonado, who explained that he had just had an armed robbery in Zone 2. According to the investigator, he stated that the first victim, Mr. Stephen Garrett, Stephen is spelled normal, Garrett is Gerrit, who stated that two suspects walked inside of a Chevron gas station where Mr. Anthony O'Neill was holding a gun and pointed it at Mr. Garrett. Mr. O'Neill told Mr. Garrett to give up his wallet and his vehicle key. After the suspects got Mr. Garrett's wallet, he told him to forfeit his key, but Mr. Garrett told him that he did not have his key at that time. Mr. O'Neill then shot in the air inside of the Chevron gas station. The suspects then went outside to Mr. O'Neill's vehicle, trying to start the vehicle, thinking that the keys were inside of Mr. Garrett's vehicle. They were unsuccessful in doing that. That is when they hijacked the vehicle of Mr. Brandon Carr, that has normal spelling, whom had the Ford Econoline van that was previously mentioned. Your Honor, the reason why this was so obvious to police that this was Mr. O'Neill and his co-defendant, Mr. Palmer, is that the one of the reasons was the 911 call for the armed robbery was at 9:28, I believe, on October 12th of 2019. The 911 call for the traffic accident was only at 9:38. There was a very short window of time in which the two 911 calls were made. They both fit the description of the individuals. There was surveillance footage that investigator Maldonado watched where he said it was clear that it was the same individuals that had just been involved in the auto accident, had also committed the armed robbery. That's why the police moved forward and took out warrants for the offenses of hijacking, armed robbery, and also because of the injury to Ms. Castano, also for hit and run for that offense, Your Honor. Your Honor, Mr. Carr, since this incident has passed on. I believe that he died sometime in 2021. The state did reach out to Mr. Garrett. Mr. Garrett's also an older individual, as Mr. Carr was. He did not want to come and relive this situation. He was fine with the state going below the 10-year minimum for armed robbery. We did also reach out to the driver of the second vehicle that had the family in it. We did not receive a response from them. Your Honor, we would, because of the severity of their injuries, if we are able to reach them and they do have any restitution requests, we would just ask for 60 days to file that request, in addition to the $7,000 that was requested by the Utica National Insurance Group. I don't believe that we will be successful in contacting them. It has been some time since the district attorney's office has spoken to them. But we believe that because of Mr. Carr's death, because Mr. Palmer was given a downward deviation as well, that this is a fair negotiated resolution. It was a very dangerous incident going from the Chevron and then the head-on accident that occurred just under 10 miles away. But Your Honor, we would ask that you accept this negotiated resolution. Your Honor, as Mr. Wright made mention, Mr. O'Neill does have two almost brand new unindicted matters. He has 23 CP 218832, which is a riot and penal institution charge that he currently has no bond for. He is a co-defendant with 4 other individuals on that case, Your Honor. That occurred on May 27th of 2023. He has a brand new aggravated battery, which occurred June 6th, which would be yesterday at the time of this plea. That is 23 CP 219110. He has 2 other co-defendants on that case, Your Honor. Because of the recency and where it occurred in the jail, the state does not have much information at all on those 2 pending matters, but he is in no bond status on both of those cases. So the state would ask that you accept this negotiated resolution, Your Honor.
Okay, that was a lot of information. So Mr. Palmer was found unconscious in the front passenger seat of the van. Couldn't really run from the hit and run. Mr. O'Neill was the guy hobbling away from the van, but his leg was so badly injured, the hobbling stopped and he collapsed and law enforcement found him. But eyewitnesses saw him leave the van in an effort to get away, but the getaway didn't work well.
That's my understanding, Your Honor.
Okay.
I know it was not a long time that had transpired since the actual accident when police were actually able to come on scene. I think it was only a 2 or 3 minute response time according to the CAD.
Okay, all right. Ms. Jackson, criminal history information, please, for Mr. O'Neill.
He has 14 cycles. The last arrest was June the 3rd, 2018 in Marietta, Georgia for a parole violation and burglary, smash and grab. He appears to be on probation in Cobb County for burglary, smash and grab. That disposition date was September the 24th, 2020, and the term is for 7 years. He does have prior felony conviction in the first offender sentence. There was one in 2016 for entering an automobile with the intent to commit a theft. And he did receive first offender treatment in 2013 for robbery. That case was sealed January the 12th, 2023. He does have a prior misdemeanor conviction since 2012 out of Hall County for a riot in a penal institution. Nothing in addition, Your Honor.
Thank you. And Ms. Tucson, do you show Mr. O'Neill as still on probation for that Cobb case?
That is correct.
And that's the
Yeah.
only case for which Mr. O'Neill is now on probation?
It is not.
Oh, okay.
Okay, so the Cobb case, he's still on probation for until 2029. And the Fulton case, 15 SC 140136, he has 2 years, 7 months, and 14 days remaining.
Okay. Are you able to tell, I can't do anything with the Cobb case, but the Fulton case, the 15 SC, did Mr. O'Neill get revoked for the facts and circumstances of this case?
I was pulling that up when you were talking about it a few minutes ago, and he was revoked on that case, and it looks like it was Judge Ellerby in December of 2019. So there was a revocation done on that.
Okay.
Because from the armed robbery, and it's been e-filed and everything.
I'm looking it up. Well, on December 2019, all that Judge Ellaby did was continue Mr. O'Neill on probation because the state failed to prove up the case. And they were not allowed to re-petition based on that. So I guess we're done with that one. The state had 2 chances in front of Judge Ellaby to do a revocation and they didn't. So your lucky day on that front. All right, Mr. Wright.
Your Honor, I guess let me start where we just finished. That sort of jogs my memory. I think I was representing him before Judge Ellaby, and that sounds right, that she ultimately dismissed the revocation because they had not brought their folks here. He did ultimately get revoked for something which caused him to go into state custody.
Maybe that was out of Cobb because it's not the Fulton case.
Was it Cobb? Okay. He believes it may have well been Cobb. So it would still apply that if it was in fact Cobb, Cobb has already revoked my client for that. So they sort of had their piece of my client, or rather the consequence of my client. So this plea won't subject him to a further proceeding in Cobb County.
It shouldn't, assuming that was the basis of the revocation.
So my client has always maintained that this, and the reason for the Alford plea was, hey, I was driving, I was a part of all that aspect that the court heard, but I wasn't a part of everything which occurred at the gas station when the actual armed robberies were occurring. But my client also now has been in ever since that day. So we would ask he receive credits, I think it's October 12th of 2019. He has been in continuous custody since that time, and ultimately is trying to turn the corner and change his life in terms of the folks he's around, and we'll just say the drama and mess that sometimes they and him have got themselves into, which have brought him before the court. For that reason, his time that has been spent since 2019 in Fulton County has been particularly harsh. I think he has been stabbed twice. His injury to the leg from the incident itself, I believe, was a compound fracture. So it was a severe break, and he still suffers from that injury, as well as the injuries he's received since he's been in custody. I do think these other CP cases will sort of resolve, but I think it is, the jail right now is a complex place, I guess, to be at. There seems to be a mix of law and order and chaos and a variety of things. My client's concern really is to say, hey, I've done the lion's share of what the recommendation to the court is. I want to be able to do the rest. I want to do it safely. And ultimately did not want to proceed with trial. And therefore he felt this is in his best interest. Ultimately, we're asking the court to accept the recommendation. It would still leave him with about 16 months of custody to do, because even, and I've explained to my client, even though under the statute, the court can sentence him under the mandatory min for armed robbery, it would still be day for day for everything the court does sentence him to. We're asking for 5 years because based on him tendering a plea, based on even what he would contend his lesser role in this offense compared to the co-defendant would be, and I understand reasonable minds may argue and differ on that this is a fair and just resolution. We ask that if the court would also recommend to DOC that if they do take him into custody, their custody, that he go to Augusta Medical or facility that he can receive medical care. But in the meanwhile, since he has these pending CPs, we would simply ask if he can remain at Fulton County until those CP cases are resolved. And that, depending on things, may well resolve the things. And also, if the court does in fact accept the recommendation of the state and the defense, asking the court to allow him the 17 to serve 5. And with that, I would just, again, ask the court to exercise its discretion.
All right. Mr. O'Neill, anything you want to add?
No, sir.
An offered plea is when a defendant says, in effect, I didn't do everything the state said, or it didn't go down quite like the state said, but I don't want to go to trial. That's pretty serious charges. If I get found guilty at trial, I could get life. I could get 40 years in prison, whatnot. So I want to try to work this out. Does that describe your situation?
Yes, sir.
Okay. I can accept an offered plea. You need to understand that it still shows up as a conviction. So this isn't like a no-low plea. These will be convictions for all the offenses that Mr. Jordan was telling you about. You understand?
Yes, sir.
Okay. All right. Well, Mr. O'Neill, I find there is a factual basis for your plea. I understand Mr. Wright has been consistent in this from way back when we had your bond hearing many, many years ago. I don't know how persuasive it would be for a jury that you just managed to get in this van in the few minutes after it was taken, such that you're driving it and you know that what went down was so bad that you need to try to run away on one leg. But I don't need to work through that today. A jury would work through that. You would have a very impressive advocate on your behalf. But I do find that the state has shown that if a jury believed the version of events that it thinks the witnesses would show, would present to the jury, that the jury could find you guilty. So I find there's a factual basis. I also find that your plea is voluntary. That means no one's forcing you to enter this guilty plea. You are standing up there with Mr. Wright because you've had a lot of time to think about it. You talked with your family and you've talked with different lawyers and you've decided this is what you want to do. Is that correct?
Yes, sir.
Okay. And a knowing plea, that just means that you don't have any more questions. And if you do, you'll let me know right now. Any questions?
No, sir.
All right. I'm sentencing you pursuant to the Probation Option Management Act. That means that when you are done with your prison part and are doing your probation, your parole, probation, if you have a minor violation, I hope you have none, but if you have a minor violation, probation will sort that out. But if it's more serious, you get arrested again, new charges, that comes to me. Mr. O'Neill, may my team sign the indictment indicating your plea to the counts you're going forward on?
Yes, sir.
All right. Mr. Wright, can we sign for you?
Yes, sir.
And Mr. Jordan?
Yes, sir.
All right. So, Mr. O'Neill, I wasn't there. None of us but you, of the folks in this room, were there. I don't know exactly how it went down, but I have heard enough about witnesses who, when living, would have said X, still alive would say X, to find that you were sufficiently mixed up in this that you ought to receive a fairly meaningful sentence. And I appreciate that your lawyer is advocating for what is still a meaningful sentence. I wouldn't want to be in jail for a month, and you've been in jail for a bunch of years. I am going to sentence you in the same way that I sentenced your co-defendant. I don't find that he was more culpable than you. I don't find that he was less culpable than you. I find that you guys were co-defendants in this scheme, trying to get Mr. Garrett's stuff. That didn't work out, so you took Mr. Carr's stuff. And fortunately, in this effort to get away, the little kid didn't die. The lady in the car didn't die. I mean, you didn't die. That head-on collision could have sent you through a windshield and it's over. Mr. Palmer, who knows? So you were pretty seriously injured. It's a good sign that you're standing there as opposed to coming out on a wheelchair. But just getting mixed up with something like this is so serious. And you're not 17, you're 28. And when I have a 17-year-old sitting here, I sort of like, of course, 17-year-olds do dumb things, but you were 24, 25 at the time. And you need to I mean, you're responsible for your decisions now. You don't get to say, "Oh, I didn't know any better." I appreciate.
And Your Honor, I hate to interrupt. One thing I didn't say in my presentation, we did get an affidavit, and I mentioned to the state from the co-defendant who did indicate my client's lesser role in the affidavit. I know because the court pointed out it was not sort of hearing a difference between the two, but even though the state takes a different position on the veracity of the co-defendant did send me that affidavit from the prison facility indicating that while my client was there, he was involved in terms of the vehicle and a lot of that part of this mess, that he was not a part of the initial stuff. And again, I just at least want to point it out since the court is drawing the similarities, but the co-defendant has expressed that. And that is the reason we're asking for him to be treated differently and why I think the state ultimately, begrudgingly maybe, but ultimately did agree to treat him differently in terms of the recommendation to the court.
Got it. I appreciate that. I think another reason is, and this isn't Mr. O'Neill's fault, it's a system failure / COVID, but it's not Mr. O'Neill's fault. If we wait 4 years to work a case out, people move on. We have a victim who's dead. I don't think the state would be recommending what they recommended now if Mr. Carr were still around. But I don't know, and I'm not engaging in hypotheticals. And most importantly, it's not Mr. O'Neill's fault that this time has passed. He has not been saying, please leave me in jail longer without a resolution. Now, he did get shipped off for the revocation, but we could have brought him back. But COVID made it difficult. Changes in lawyers made it difficult. And this slow pace has bad effects for everyone involved. Mr. O'Neill doesn't get closure. Mr. Carr passes away, et cetera. So, all right, here's what I'm going to do. And let me get to all those counts. On count 1, I am sentencing you to 5 years to serve. Counts, and that will be pursuant to 1710 6.1E. 5 years to serve. Where's your indictment? So 2 and 3 went away. Counts 4 and 5, I am sentencing you to 12. Is there a +5 in here? There is a +5. I'm sentencing you to 7 years to serve. Those will run concurrently with each other and concurrently with count 1. I'm gonna come back to count 6. Counts 7 is 12 months to serve. 8 is 5 years to serve. 9 and 10 are 12 months to serve. And 12 is 7 years to serve. All those run concurrently with count 1. And finally, count 6 has to be 5 years, has to be consecutive. It will be consecutive to count 4. So the total sentence is 12 years to serve 7 years, credit for all the time you've been in. And again, count 1 is 5 years to serve. This is subject to 1710 6.1E. You will be on probation, maybe some parole because of the way I've structured this. Special condition of probation number 1, no contact with Mr. Garrett or Jarrett, Gerrit. He's a stranger to you. Special condition number 2 is that you pay $7,889.45 in restitution to the Utica National Insurance Group. That's it for special conditions. I will recommend that the Department of Corrections house you in a medical facility. Maybe it's Augusta Medical, maybe it's not. But that is the recommendation I will make to the Department of Corrections. Did I leave anything out of the conditions of probation, Mr. Jordan?
No.
All right. And we don't have anything to do with probation because Judge Ellerby has foreclosed a revocation based on these facts in her case, and Cobb may have already dealt with it. There are two open CP cases. Those factored into my decision not to do something radically different from the co-defendant, but it is nonetheless different from the co-defendant. Anything you want to add, Mr. Wright?
Your Honor, and part of your sentence is if and when he goes into DOC custody, is the court willing to make a recommendation?
I did. You were explaining to Mr. O'Neill.
I'm sorry.
What I figured you were explaining, but I made that specific recommendation.
Okay.
Okay.
That's all I guess we have on the defense, Judge.
Okay. All right, Mr. O'Neill. Changing your way of doing things is not easy. You have people who care a lot about you. They've been sitting in court all morning. They've been in court before. You owe it to them and to yourself when you do get out to try to run things a little bit differently. I was looking at your case with Judge Ellerby. That was a whole lot of cars you broke into. This was even more serious. It's only going to get more complicated for you if you keep running in this way. I say that like it's easy to change. It's not, I get it. But I hope you can. I hope that when you get out, you really commit yourself to trying to do something differently, because otherwise it's going to catch up to you, and either you're going to get locked up for a while or you're going to get shot in the head. And that's the worst ending of all. So I hope that it works differently for you next time. All right.
Yes, sir.
All right. Thank you, everyone.
Okay. Judge, that concludes my business. May I be excused?
Yes, sir.
All right.
We need to give everyone a break for lunch. We will reconvene about 1:30. So that's 40 minutes for lunch. Is there a particular order in which you want me to do things when I get back? I know we need to get Ms. Hall back here. What I'd love to do, if there are people not in custody, I just don't remember the names. So if you tell me the names, we'll do that first. That's Mr. Hopkins. So why don't we?
I will check and see if that one's ready to go, Judge.
Okay, if it's not,
Break.
got it. But let's aim to do Mr. Hopkins first, and then we still have Kuntz, which I think we're doing last. Walker and Huff, I was told.
Huff is ready, Judge.
Okay. So if Hopkins is ready to go after lunch, we'll need Ms. Hall for that. Then let's do that first. Otherwise, we'll do Huff. Is Walker ready to go?
That I just need to get him on the Zoom, but it'll be ready otherwise.
Oh, this is the Colorado guy. So we'll do that. He's here. Okay. You can coordinate with him, and we could do him first if Mr. Hopkins, I know he's ready, but if the lawyers aren't ready for Mr. Hopkins at 1:30-ish, let's do Mr. Walker.
Okay, sure.
Great. Thank you, everyone. I'll see everyone who's plugged in virtually back at about 1:30. I will mute the machine in here. All right. Ms. Rivers, can you hear us?
Yes, I can.
Great. How's your day been?
It's okay.
Okay, well, we're glad you're with us.
Thank you.
So we have Ms. Hall here. Does that mean we can move forward with Mr. Hopkins's plea, or are we going to do Mr. Walker? I guess Ms. Wood went back there, so let's do that. All right, that is position 19. All right, are you ready to go, Ms. Hall? Okay. This is position 19. It's indictment 22 SC 184076, State versus Dequarius Hopkins. Mr. Hopkins is here in court with his lawyer, Ms. Feely. Ms. Hall is here for the state. Mr. Hopkins, you're ready to enter a plea in your case?
Yes, sir.
Okay. Ms. Hall will put you under oath in just a moment. After that, you'll need to answer a bunch of questions from her. If you have questions, please let Ms. Feely or me know. Okay?
Okay.
All right. Ms. Hall, when you're ready.
Thank you. Keep these on your right hand. Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, my lawyer hand. Please state your true, correct, and legal name.
Dequarius Devlin Hopkins.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone to school?
30 in high school, some college.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? False imprisonment and 2 counts of sexual battery?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
I need us to pause for a second because I'm confused. The indictment in this case charges Mr. Hopkins with rape, aggravated sodomy, and false imprisonment. Are we pleading to a different case number?
Yes, Your Honor, which case, what was the last 3 of the
I
cases?
gave the one that's on the calendar, which is 184076.
076. Not sure if you didn't receive the no price form from this 88 Falls. That case was should have been no price, and then we re-indicted the case. The new indictment number is 23 SC 187932.
Okay, I do see that as a related case. There is no null pros for the 076 case. Are you moving to null pros it?
Yes, Your Honor.
All right, I'll make sure Ms. Nelson takes care of that. And let me, hold on one second. So Ms. Rivers, we're actually, this record, this transcript would be under 23 SC 187932, which has those charges you just mentioned. I'm much better. And it's a accusation, and it looks like there's a waiver of indictment in the docket. Okay, good to go.
My apologies, Your Honor. Mr. Hopkins, do you need more time to discuss this case with your attorney?
No.
Are you satisfied with your services?
Yes.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the accusation, including with respect to the defendant's name?
We do.
Ms. Hopkins, have you been arrested on these charges?
Yes. Well, not those charges, but the other charges. Yes.
I ask because the state is unaware of any outstanding warrants that related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes.
Minimum maximum sentence for false imprisonment is 1 to 10 years to serve. Minimum maximum or the maximum for sexual battery is 12 months to serve. You understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of For count 1, false imprisonment, 4 years probation. For count 2 and count 3, 12 months probation for them each to run consecutive to count 1, totaling 6 years probation. Special condition that you have no contact with the victim in this case. Trish Anna Jacobs, 150 hours of community service, complete a psychosexual evaluation and follow up with any recommended treatment. Seek and maintain gainful employment, no alcohol, no drugs without prescription. But the court does not have to accept their recommendation. The court can sentence you to the maximum on these charges or can run them consecutively one after another. Do you understand?
Yes.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
We are asking for first offender, but understood.
Do you understand this plea do you understand if you're placed on probation of any kind, you cannot violate any criminal laws or any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contraende to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained the First Offender Act to you?
Yes.
Do you understand if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this accusation?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
In indictment number 23 SC 187932, how do you plead to the charges of false imprisonment and 2 counts of sexual battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days from today to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes.
Thank you. Your Honor, had this case proceed to trial, the state would have proven beyond a reasonable doubt that on April the 1st, 2018, an incident occurred with the defendant and the victim in this case, Ms. Jacobs. They met on a dating app called Tinder. At the time, she was not living in the state of Georgia, but she came down. They agreed to meet. When they met, they had dinner. They went on a date. After that date, they went to the defendant's home where the defendant tried to have oral sex with her and eventually did have vaginal sex with her. The victim did go, and this was without her consent and with her saying multiple times to stop and that she didn't want it. The victim went back home, went back to New York, where she communicated with the defendant and tried to get the defendant to admit to what he had done via text messages. The only real admission that he made was that he should have stopped, but that was really it in as far as the communication. 2 years later, in 2022, she came down to Georgia. She saw the defendant in a club, tried to approach him about what happened. He, in her recount, acted like he didn't know her, which offended her. After that, she went back home, posted something on Twitter to try to understand who he was because she met him on Tinder. She didn't know his real name. Once she made those posts onto Twitter, a few women reached out to her, one of which being the defendant's ex-girlfriend. She told our victim, Ms. Jacobs, his full name and his date of birth. At that point, she did report the assault that happened 2 years prior. There was no sexual assault kit done in this case. As you can imagine, it was reported 2 years later. The case was essentially reduced and reaccused by my colleague, ADA Charles, because after speaking with the victim and having this case for such a long time and investigating it, the state believes that there will be a challenge if this case were to go to trial as far as proving the rape. But what was worked out between my colleague and the defense counsel was to re-indict it because there was a time when the victim was inside of the defendant's house and he wouldn't let her leave until she gave him a kiss. She did that and then she left. That's why the charges for false imprisonment remains. We've spoken with our victim. She understands the risk of going to trial with such a lack of evidence in this case, and she understands the decision that we've made, and she didn't want to speak or be present today.
Okay. And you may have just woven that in there. Is she back in New York, or there's little risk that other than that they managed to bump into each other at a club when she was back in Georgia? But if she stays out of Georgia, she's not going to bump into Mr. Hopkins.
Correct.
Okay. Not that she needs to do anything. But, all right. Got it. Good afternoon, Ms. Jackson. Do you have any criminal history for Mr. Hopkins?
He has 2 cycles. The last arrest was June the 24th, 2022 in Lawrenceville, Georgia for driving without a valid license. He does appear to have an outstanding hold in Lawrenceville, Georgia for a failure to appear. The date on that warrant is August the 10th, 2022. Nothing in addition, Your Honor.
Okay. We'll need to look into that. But let's stay focused on this. Mr. Hopkins, I'm going to hear from Ms. Feely, and then if there's anything you want to share, you can do that. Ms. Feely?
Thank you, Your Honor. As you might imagine, we have much different version of what took place between the two of them that night. Then, unfortunately for us, it would just be our word versus her word. We do believe that she was insulted that he didn't recognize her, and that may have led to the decision that she made in 2020 to report this as an alleged rape. But as the court heard, April 1st, 2018, this happens, and then they run into each other again. And on June 4th, 2020 is when the allegation is made. Mr. Hopkins has no criminal history. The suspended license I was not aware of, but that's the extent of his record, it sounds like. He has no violence, no drugs, no guns, nothing in his background. And he has not been accused of engaging in criminal behavior since this alleged incident in 2018 and when it was reported in 2020. So we don't have to guess how he'll do. I'm confident he will do exactly what he's been doing, which is staying out of trouble. Unfortunately, we just couldn't quite roll the dice with the high stakes of the original indictment.
Yeah.
Which is why we find ourselves here. But he's 30 years old. He's single, no children. He's very career focused at this moment, which is going to lead me to another thing I wanted to bring up. He does photography. He's a party promoter. He's a tattoo artist. He's just got a lot going on. And for that reason, we are going to be asking the court, similar to an earlier case today, to restrict his record while his first offender is pending. And I have an order that I will need to tweak because it says with no opposition from the state, but I believe they do oppose. So I will change that. But we are asking the court to consider sentencing him as a first offender, following the state's recommendation, and having his record be restricted while pending discharge.
Okay. Got it. And so you explain, Ms. Hall, Ms. Jacobs understands one, the re-indictment or re-accusation and this outcome based on the way in which this scenario played out. And I remember you saying she didn't have anything to add beyond what you shared.
Correct.
Okay. All right. Mr. Hopkins, anything you want to add?
About the failure to appear, I didn't get a notice for that.
Okay. There may be all sorts of good explanations. We're just checking if there's a valid warrant
It was probably because when I did get pulled over,
Well, let's just focus on this case for now, and then we'll deal with the warrants.
Okay, yeah, what I was gonna say is if there's a valid warrant, you don't get to leave today. You gotta go deal with that. If there's not a valid warrant, you probably still want to go to Lawrenceville and say, what's going on? But you wouldn't be working it out in front of me anyway. You may have had a valid license. You may have had the wrong license. Who knows? But we're looking into that. Is there anything you want to say about this situation? You don't have to say anything, but there may be something that you think Ms. Feely missed or that you disagree with that Ms. Hall said or whatever.
no, everything's good.
Okay. What is your primary source of income? Is it doing tattoo work or party promotion or what?
All three.
What's the third?
Photographer.
Photography. Okay. So you make exactly 1/3 of your income from each, or is that's a happy coincidence?
I'm take care of bills.
Okay. If you could do more of one and less of the other, what would you dial back and what would you do more of?
I will fall back on tattooing and do more focus on party promoting and photography because those kind of go hand in hand with me being in the club.
Sure.
And working with celebrities and other stuff like that.
Mhm. Do you have a booth or a store? Where do you do your tattoo work?
I was renting out this booth, but I've been done with that for about a year. I took a break.
So you're more of the party promotion and photography. Okay. All right. Any questions about anything we've discussed?
No, sir.
Well, let me talk real briefly about first offender. Ms. Hall was very thorough in covering it, but I got to make sure myself. Mostly first offender is an opportunity. It means that you don't have a conviction. This plea is not a conviction. You don't need to tell anyone that you're a felon because you're not. You are a first offender. You'll be under sentence, but it's not the sentence of a felony conviction. Helps with work, with job, with school, if you're going to go back to school, et cetera. That's the benefit of first offender, assuming you successfully complete your sentence. If you mess up, and it doesn't seem like you would based on your lack of criminal history, but so you know, if you mess up as a first offender, not only could you have your probation revoked, but if the state sought it or I thought it was appropriate, you could be resentenced. You've already said, I did this, so you don't get a trial. You'd have a hearing and your lawyer would be there, but you could be resentenced as a felon. And given these charges, it could be up to 12 years. So right now you're getting just probation, and I'm making this up. 2 years out, you get arrested for sexual assault. Hey, I'm going to challenge those charges. That's great. You can get a lawyer and you'll have that separate case, but you'd also come back here and the state with a much lower burden of proof. If they convinced me that you were involved in that sexual assault, I'd say, we really misread this situation. And I could take away your first offender status and say, I'm going to sentence you to 6 years or 8 years, more than the sentence that you're getting right now. That's not good. But if you're pretty sure you're not going to get mixed up in anything that gets you in trouble, first offender makes a ton of sense. I just need to make sure you understand the downside, that risk that can really blow up on you if you are going to be moving in the wrong circles.
I'm 30. This is my first offense. I can handle it.
Okay. I wasn't doubting you could handle it. And Ms. Feely has wisely counseled you and I think aptly described your situation as one where this is way off the reservation for you. These allegations are. Okay. I will sentence you as a first offender. I find there's a factual basis for your plea to false imprisonment and 2 counts of sexual battery. I find that your plea is knowing and voluntary. Voluntary means you've decided all on your own with counsel from others that you want to go forward with this and no one is forcing you to do that. And knowing means you understand everything we've been talking about. You don't have any questions. Are both those correct?
Yes.
All right. I'm sentencing you under the Probation Options Management Act, which means that while you are on probation, if you have a minor infraction, you and probation will sort through that. You don't have to come to court. But if it is more serious, you get arrested, new charges, something like that, it comes back to me. Mr. Hopkins, may a member of my staff sign the indictment on your behalf indicating you've pled guilty?
Yes.
Ms. Feely?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
All right. I am going to sentence you, Mr. Hopkins, as to count, look at the indictment again, the accusation. Count 1 will be 4 years. Counts 2 and 3 will both be 12 months. Those will run concurrently with each other and with count 1. So my sentence is a little different. I'm giving you 4 years probation. I think that's more than enough for us to figure out, is it the Mr. Hopkins on every other day of his life than April 1, 2018 that we're dealing with, or were there more things like April 1, 2018? And we'll know that within 4 years if you are handling things the right way. Special condition of probation number 1, no contact with Trishana Jacobs. That should be easy, but make it so. Number 2, 150 hours of community service. And then 3, you'll submit to a psychosexual evaluation. And if that evaluation yields any recommended treatment, that treatment will become part of your probation. Ms. Hall, anything else as to Mr. Hopkins?
Another part from the state.
All right. Ms. Feely?
Only the court's decision about restricting his record while he's on first offender.
And I'll look at the proposed order.
And finally, Your Honor, he has been on an ankle monitor all this time.
Oh.
And so I don't know if he needs guidance from probation or who would send him in the right direction to get it removed.
Yes, it will come off. And I don't know if you go to A&A or A&A comes to you, but let's ask.
So I'm not with A&A anymore. It was a private company that pretrial services approved for, so.
Okay, you can be with B&B. Whoever it is, you may want to reach out to them. They may need to see the final disposition, your sentence, and that would be proof, oh, he doesn't need an ankle monitor anymore. If I need to sign something, I'm happy to sign something. Probation ought to be proof that you're under sentence now. But I guess the smart route would be to reach out to that other provider to say,
So do they need to contact you or pretrial services?
well, you're done with pretrial services as of today, and you're transitioning from pretrial to post-trial, post-plea, which will be probation, Department of Community Supervision. And in just a moment, you're going to hear the voice of Ms. Tucson, who is with probation. She's going to give you reporting instructions, and she may have an answer about the ankle monitor. If she doesn't, then my suggestion is that you call the ankle monitor company saying, I just pled, now I'm under sentence. Come get your ankle monitor. And they may say, drive to our address. They may come find you. I know they want the equipment back.
Yeah, they would probably drive to me.
All right. Ms. Tucson, you want to give Mr. Hopkins his reporting instructions?
No problem. Mr. Hopkins, what city do you live in?
Smyrna?
Is that Cobb County?
Yes.
Okay, just making sure. Okay, so I'm gonna give you, I need to take your address and your phone number, but I'm gonna give you the address to their office. And Ms. Feely, on this case, is he gonna be required to register or no?
No.
Okay, just making sure because it'll flag it if not. What is your phone number, Mr. Hopkins?
470-838-0761.
And your address?
1806 Walton, Walton Lane, Lane, Southeast Smyrna, Georgia, 30082.
All right, I'm gonna call you as well to that way I could send you reporting instructions. However, on the record, I'm gonna give you the Cobb County office to report. That is COBB. It's in Marietta. It's 590 Commerce Park Drive, Suite 102. And that's Marietta 30060. And you're gonna want to report June 22nd.
Okay.
Okay, that's sweet. Second note. Did she give you a date? What date did she confirm?
So we've confirmed there's no warrant. Did you hear something different? Okay, Ms. Nelson contacted the warrant division. Would you trust the warrant division? Okay, All right, that's good enough for me then. They say no warrant. That doesn't mean, Mr. Hopkins, just so you know, if, yeah, you could be driving and oops, maybe it was a rolling stop, you get pulled over. And all they can do is issue a warning and then a warrant pops up. There goes your weekend. So reach out to Lawrenceville.
Okay.
Ms. Hall, anything else in the Hopkins case? All right, Ms. Feely?
No, Your Honor.
All right, thank you, everyone. Yes, you may. All right. Walker, Huff, those are the two I know of, but happy to do more. We're open for business.
To Mr. Walker, since he's been waiting patiently, Judge, on Zoom.
Is he the Mies iPhone?
I think so.
Yeah, that's it.
Okay, let's do it. So this is position 18, Ms. Willingham and Ms. Feely. Where are you gonna be right there still?
Yes, since he's on Zoom, I guess I'll.
You can be wherever you want. I just want to add the spotlight and Ms. Feely so he can see, if you don't mind sliding over one. I know you love the camera. All right, that's everyone we need. Okay, position 18, 22 SC 183897, State versus Giovanni Walker. Mr. Walker is joining us. Where in Colorado are you?
I'm in Denver.
In Denver, okay. From Denver, Colorado. His lawyer, Ms. Feely, is here in court, as is Ms. Willingham, the prosecutor. Mr. Walker, you have a right to be here in court. Are you waiving that right and consenting to a remote appearance for your plea?
Yes.
You also have a right to have your lawyer, Ms. Feely, right next to you so that you can consult with her if you have any questions. And we can still make that happen. She can step outside and call you on her cell phone, but she's going to be here and you're going to be in Denver. Do you waive your right to have Ms. Feely by your side?
Yes.
Okay, you'll let me know if you've got any questions for her?
Yes.
All right. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Please state your name, your age, and your date of birth.
Giovanni Walker. I'm 25. My birthday is April 26, 1998.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Some college.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, the right to not incriminate yourself, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The state's recommendation in this case, as to count 1, is 3 years probation, and as to count, that is, I'm sorry, Judge. Give me 1 second. This is my old one. I'm sorry, as to count 1, it will be reduced to a simple battery family violence. And I will provide those code sections to you, Ms. Nelson, via email. As to count 2, it will also be a simple battery family violence. and each of those will have 12 months probation. Both counts will run concurrent. He's to have no contact with the victim, complete family violence intervention program or its equivalent in Colorado. It's my understanding they may not have a family violence program, but they do have anger management. Complete 60 hours of community service, no weapons, drugs, or alcohol.
How many hours of community service?
60 hours.
60.
Is that what was communicated to you?
Yes.
You're pleading guilty today to 2 counts of simple battery family violence, both with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
The negotiation in this case is a total of 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 24 months?
Yes.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete the family violence intervention program or its equivalent, complete 60 hours community service, have no weapons, drugs, or alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No, I don't.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you're pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
Your Honor, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on September 16th, 2019, at 6:17 a.m., Officer McKeithen responded to a call at 3200 Lenox Road Northeast regarding a dispute. 911 call remarks read that Alexis, the friend of the victim, Destiny Citizen, witnessed her getting punched and dragged down the hallway of her apartment complex by her boyfriend, Giovanni Walker. Another concerned citizen also called 911 and stated that he witnessed a Black male, 5'10", black pants with an afro and silver sweater, beating a female wearing long sleeve sweatshirt in a parking lot. Witnesses stated that both the suspect and the victim left the scene in a white Mercedes SUV. Upon arrival to the complex, Officer McKeithen saw the suspect's vehicle leaving the scene of the incident and initiated a traffic stop on the roadway of Lenox Road Northeast and Crane Road Northeast. Officer McKeithen made contact with the driver, Giovanni Walker, by approaching the vehicle that he was traveling in. As Officer McKeithen approached the vehicle, he noticed that Walker was sweating profusely and looked extremely nervous. Walker stated the Black female in the passenger seat is his girlfriend, Destiny Citizen. Walker stated the 2 live together but have no children together. And Officer McKeithen witnessed the discolored bruises on the victim's face and scratches around the victim's neck area. Walker told Officer McKeithen that they just had a verbal dispute, but it was nothing physical. Citizen stated that earlier that night she was at the club Blue Lagoon and got into a fight with another female that caused her sustain bruises to her face. Walker was detained by Officer McKeithen and later arrested and transported to Fulton County Jail. I've had an opportunity to speak with the victim in this case, Your Honor. We've talked once and she has subsequently not returned calls. She does not deny that this incident happened. However, she has moved on with her life. She has not had any communication with the defendant. She wishes for it to stay that way, and she was not really interested in proceeding forward at this point in time.
You have a lot of cases where you talk to them once and they don't want to talk to you anymore.
Yeah, Judge, that seems to be the case. Hopefully they
not
don't
you.
have to contact me again for other reasons.
Right. What is your understanding of how misdemeanor probation will work? And this may be a question for Ms. Feely. Mr. Walker is in Denver, Colorado.
So I actually had another case in another courtroom where the defendant was actually in the military. Misdemeanor probation got his contact information. They called him and they are going to have him do call-in reporting.
Okay. We'll see how it works. That's up to
Yes.
misdemeanor probation to let us know if there's an issue. I know it would be a problem with felony probation, but that's not where we are. Okay. So Ms. Citizen is not objecting to this outcome.
She's not, Your Honor.
And as best you could tell, she and Mr. Walker are no longer an item.
That is correct. And Your Honor, I also would add that in my first communication with her, she also states that this incident didn't happen the way that it appears.
Okay. It rarely does. All right. Ms. Jackson, do you have any criminal history information for Mr. Walker?
He has 7 cycles. The last arrest was October the 30th, 2019 in Cobb County for a probation violation. He does have misdemeanor convictions. There was one in 2018 out of Cobb County for battery, family violence, and simple battery. And there was one in 2017 out of Cobb County for possession of marijuana, less than an ounce. That's an addition, Your Honor.
Thank you. Ms. Feely.
Your Honor, so as you heard, Mr. Walker is 25 years old. He works reffing basketball games for a living, apparently, from what he tells me. We are asking the court to accept this plea as negotiated. As the court heard, it's a September 16, 2019.
Okay, we got some aged cases on this calendar.
And should this proceed to trial, we have a much different opinion of how that might go because our version of events is also significantly different. But given the state's offer, Mr. Walker's location in Colorado, we are asking the court to sentence him.
Okay. Got it. Mr. Walker, are you a roaming ref, as in you're sometimes in Colorado, sometimes you're in Texas, or is all your reffing in Denver?
I'm stationed in Denver.
Well, you make it sound like the military.
So it's possible for me to go out of state, but I've never been out of state, and I've been reffing for 2 years. So
okay. What level do you ref?
I do all ages from kids up to high school. I've done some college games. It's baseball season now, so I'm doing baseball as of right now.
Oh, so you are not just a basketball, you do a multi-sport adjudicator.
Right.
Basketball, baseball, also football?
Football. I haven't done any football games yet because I haven't done the training, but it's soccer, kickball, it's everything.
Kickball. I didn't know they had refs for kickball. Okay. And that is your primary source of income?
Yes.
When's the last time you had any contact with Ms. Citizen?
Hasn't been since that incident.
Way back in September 2019.
All right.
How long had you known her before that situation?
Since we were younger, probably like 12, probably.
So why have you not been in touch with her since September 2019?
Because I realized that situation is not in my best interest. So.
Okay. All right. You have any questions about anything?
No, sir.
Do you authorize my coworkers to sign the indictment on your behalf indicating your plea to the 2 misdemeanors?
Yes.
Ms. Feely and Ms. Willingham?
Yes, Your Honor.
All right. Well, Mr. Walker, I find there's a factual basis for your pleas to family violence, simple battery. We don't need to talk about whatever the different version of events would be. It does sound like a police officer witnessed Ms. Citizen with some evidence of injuries about her. And I think that's enough for purposes of the plea to support the plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to go forward with this, but you've decided that's what you want to do. Is that correct?
Yes.
And a knowing plea simply means you've understood everything. Questions about anything we've talked about so far?
No.
Okay, then I'll accept your plea. I will follow the negotiated terms and sentence you to 12 months on both counts and run those concurrently with each other. So it's a total sentence of 12 months probation. Special condition of probation number 1 is no contact with Ms. Citizen. That should be pretty easy for you since you've been doing just that for the last few years. Number 2, complete 60 hours of community service. And finally, you'll need to complete a family violence intervention program or its closest equivalent in the state of Colorado. They ought to have something that is along the lines of anger management, family skills. Sometimes they call it parenting skills. I'm not suggesting that you are the parent of Miss Citizen's kid, but sometimes those curriculums overlap. So we'll see what you can find there in Colorado. How long have you been living in the same place in Denver?
About, I want to say about a year.
Are you planning on moving, or Denver is it for a while?
I'm staying in Denver, but I am going to move into a different spot.
Okay,
I'm staying with family as of right now.
Got it. All in Denver.
Yeah.
Okay, good. Well, I think that is it. Ms. Feely, Ms. Nelson is going to send you some paperwork from misdemeanor probation for you to fill out and then coordinate with Mr. Walker. Mr. Walker, you will be on probation for 12 months. The probation office is here in Atlanta. I'm not expecting you to come to Atlanta to report unless there's an issue. But if things are going smoothly, it's my understanding that they will let you dial in, call in to report, and then you'll just need to provide documentation of your completion of these different requirements. Your community service, you ought to get timesheets from the agency or the pro bono, wherever you're contributing of your time. But all that type of documentation you'll be sending back to the probation folks here in Atlanta, okay?
All right.
You have questions about anything?
No, sir.
Ms. Willingham, anything else in Mr. Walker's case?
Nothing further, Your Honor.
Ms. Feely? Okay, I think that's it. Thank you.
Thank you. So, I actually do have a question. I'm sorry. So what do I do now?
What do you do now? Ms. Feely will be in touch with you. She will get the information about misdemeanor probation. And then you will be reaching out to misdemeanor probation saying, hey, it's Mr. Walker. Here I am. Here's my address. Here's the best way to reach me, etc. Okay?
All right.
So Ms. Feely will be in touch with you.
Okay.
All right. You're free to go.
Thank you.
We do Huff?
Up next, yes, Judge.
Okay.
Thank you.
Sure. Number 21.
About William. Just on your plea. I know. But that's okay. I've been working while I've been sitting.
There.
Oh, you can stand up if you need to sit. You okay? Okay.
You sure? It's okay if it's easier to sit. You tell me.
I'm okay.
Okay, standing it is.
Just 1 second, Judge.
Okay.
Are we all right?
Yes, Your Honor.
Okay, this is position 21. It's indictment 22 SC 184865, State versus Huff. Mr. Huff is here in court with Ms. Wood, and Mr. Peoples is handling the representation of the state. Mr. Huff, Ms. Wood tells me you're prepared to enter a plea. Is that right?
Yes, sir.
Okay, you seem not sure. Is that, you understand what we're doing?
Yes, sir.
Okay, great. Mr. Peoples is going to put you under oath in a moment, then ask you a bunch of questions. I may have some as well. It's important that if you have questions, you're not sure about something, you're confused, or it's just not going the way you and Ms. Wood had talked about, that you let Ms. Wood or me know that you've got a question so that she or I can answer it. Will you do that?
Yes, sir.
All right. Mr. Peoples.
Yes, Your Honor. Please raise your right hand. As best as you can. You solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
People, get near the microphone, please.
Sure.
You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. And you want to speak up as loudly and clearly as possible. Okay.
Outdoor voice.
Yes.
Okay.
Will you state your true, correct, and legal name?
Jonathan O'Brien Huff.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you?
40.
You say 40?
40.
And what is the highest level of education that you've completed?
College.
Okay. Are you able to read, write, and fully understand the English language?
Very well. Very well.
Oh, good. You understand that you're currently charged with a single count of aggravated assault with a sentence range of 1 to 20 years?
Yes.
I think it's 3 to 20 years because it's family violence, aggravated assault.
I believe you're right, Your Honor.
It's not going to change anything, but just so you know, the lowest sentence I could give you would be 3. It could be 3 years probation. Is this not? Is it,
There will be more in a minute, Judge.
Okay.
I just didn't want him to freak out.
okay.
Mhm.
All right.
You understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
So waived.
You understand that this is a negotiated plea of guilty, which means that the recommendation of the state and the defense to the court, Your Honor, would be asking that this be reduced to a simple assault under OCGA 16-5-20.
Okay. So never mind about that 3 years.
And that would be all, Your Honor. We would have been asking for 12 months of probation. However, he served a little bit over 296 days at this time. So we would not be asking for anything else. We'd actually be asking for 1 year credit for time served.
Okay.
Credit for time served.
12 months to serve reduced to time served, or 12 months to serve, he'll get credit for time served, and that number is a little more than 300 now, but is the recommendation that he serve 12 months?
Reduced to credit for time served.
reduced to time served.
So I think, Judge, it might be cleaner if we just did 11 months to serve because he's almost there. Within a week, he'll be at 11
Right.
months.
Okay.
Let's say we'll be fine with that, Your Honor.
Okay. Got it.
Do you understand that, Mr. Huff?
Yes, sir.
You understand, however, that the court does not have to accept this recommendation and the court can sentence you to the maximum on this charge.
Yes, sir.
You want to make sure you speak up so that the.
Yes.
Thank you. You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts.
Yes.
Are you a citizen of the United States?
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty.
Yes.
There are certain rights that you give up when you enter a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or the court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand those rights?
Yes.
Has anyone used any force, threats, or promises which has caused you to enter a guilty plea against your will?
No.
Is it your decision to waive all of those rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of simple assault?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that unless counsel is substituted or permitted to withdraw, that defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for a felony to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes.
You understand that in the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on July 14th of 2022, law enforcement was dispatched to a call at 1050 Ponce de Leon Avenue Northeast in Atlanta, Georgia, in Fulton County. Upon arriving, they met with the victim, Miss Alicia Bowman, who stated that her friend, Mr. Huff, identified as Mr. Jonathan Huff, had punched her in the face. The security guard, Mr. Rico, common spelling, Ross, common spelling, had witnessed this on Miss Bowman, and Mr. Huff then fled the scene and was not at the location when the police arrived. Counsel, do you stipulate that there is a factual basis for this plea?
We do.
Thank you. And that's all from the state, Your Honor.
Okay. Have you or has someone from your office discussed this with Ms. Bowman, and does she have a perspective on this resolution?
I believe that Ms. Willingham had spoken to Ms. Bowman prior to this, because this is initially a domestic case.
Well, that means she spoke nicely one time and refused to ever talk again to the DA's
I
office.
actually think this case, I believe ADA Whitenauer had a conversation with Ms. Bowman. If you give me a moment, I can pull up the notes and get what that was.
Just to make sure we're factoring in Ms. Bowman's perspective. I'll note this is actually a relatively recent case. This is less than a year old. Not just the indictment, but the incident. We have some recent indictments from 2018.
No, it's fine. Your Honor, it looks like back on July 15th of last year, a victim advocate spoke with the victim following court. And at that time, she was advised that it was a bond motion. So at that time, she was advised that the defendant was denied bond. And it doesn't appear she gave much of an opinion as to what she wanted to see happen with the resolution of the case. She was just provided information to be able to register on bond.
Okay. And that's it in terms of contact your office has had.
Yes, it looks like we have attempted to contact her multiple times since then via friends' information that we were provided, but it looks like everything came up to a dead end.
Okay, thank you. All right. Anything else, Mr. Peoples?
No.
Okay. Ms. Jackson, do you have any criminal history information for Mr. Huff?
Yes, Your Honor. He has 22 cycles. The last arrest was April the 26th, 2021, with the City of Atlanta Police Department for burglary in the first degree and financial transaction card fraud. He does appear to be on first offender probation in Fulton County for burglary in the second degree. That case number is 21 SC 179723. That disposition date was February the 1st, 2022, and the term is for 5 years. He does have misdemeanor convictions. There was one in 2013 out of Marietta, Georgia, for theft by shoplifting, and there was one in 2010 out of Alabama for a traffic offense. Nothing in addition, Your Honor.
Thank you. Just looking at the other case. Okay, Ms. Tucson, do you have Mr. Huff as being on that first offender probation?
Yes, Judge, in 21 SC 179723.
Yes, ma'am.
Yes, he's on probation for that case.
Okay. All right. Ms. Wood.
Judge, it doesn't look like I don't see that it's had a revocation hearing or anything, but there is a hold for that, as you may be able to see. So I did just want to let you know that once this case is resolved, he understands that he has to deal with Judge Ingram's probation matter. He is 40 years old. He's originally from Mobile, Alabama. He's been here in Georgia the past 10 years. He's a graduate of Alabama A&M. He played football there. He's a Navy veteran. He worked in commercial roofing previously, although he does have an injury, so I don't think he's been able to work recently. He also has 3 children over in Alabama. Judge, he's been in 329 days, so since July 14th of 2022. I myself have not spoken to the complaining witness. He has indicated one of our pre-indictment attorneys, Ms. Gowdy, spoke with the victim quite a bit and that she was pretty much indifferent at this point. So that is my knowledge of that. We just ask that you accept the state's recommendation.
Okay. Mr. Huff, you've got 3 kids. How old are they?
My oldest is 22. I have a 20 and a 13.
Okay. And none of those kids is with Ms. Bowman?
No.
Okay. Are they in the Atlanta area? Or I guess she said they're in Alabama.
They're in Alabama.
Okay. What brought you to Georgia?
Work. I
Work.
came over here working for a company out of Lawrenceville. And I actually met Miss Bowman after I was released last year.
Released
On
for
this
the case that you're on probation for?
Yes, sir.
Oh, okay. All right. Are you intending on reconnecting with Ms. Bowman when you get out?
I don't want to meet nobody last name Bowman.
Okay, no Bowmans at all.
period.
Okay, not Bill Bowman or Fred Bowman. All right, got it. Well, may you have success in that adventure. Are you going to be able to go back to the roofing work you were doing? I know you're injured, but
I have to go to the Veterans Hospital first,
okay,
and then I still have my job.
okay.
I'm an accountant there, but
So you're not up on the roof putting stuff. You are adding numbers up and making sure money in, money out.
Right.
Okay. Do you have an accounting degree or background?
My degree is in mathematics and computer science.
Okay.
But my minor is in statistics.
That seems like more than enough to be an accountant. The injury that you have, is it related to your service in the Navy, or it's unrelated, but you are able to get treatment at a veterans hospital?
I was stupid enough to play football against an NFL linebacker in college, and I got hit earlier, but I won't be doing that no time soon either.
Okay. Especially if his name is Bowman, you'll be safe. So, all right, Mr. Huff. Well, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Do you have any questions about anything we've discussed?
No, sir.
Okay, I'll accept your plea. May someone on my staff sign the indictment indicating your guilty plea? Sign it for you. We don't have the indictment out here. We're trying to do that electronically now. Is it all right if we sign on your behalf?
Yes.
And Ms. Wood?
Yes, Judge.
And Mr. Peoples?
Yes, sir.
Great. I will not mess with the probation in the 21 SC case. It sounds like you'll get in front of Judge Ingram for something to happen with that. And I will sentence you in this case, which has been reduced to simple assault, to a term of 11 months to serve, and you will get credit for all the time you have served from July 14th onward. So you are about a day or two away from 11 months. You ought to be out by the end of the week. If you're not, reach out to Ms. Wood or Ms. Feely, and they'll let me know and we'll fix it, okay?
Yes, sir.
Do you have a place to go when you get out?
Yes, sir.
Where's that?
With my uncle. My
Okay, is
uncle
that
lives
where
here.
you were living before?
Yes, sir.
Okay, so he'll let you come back.
Yes, sir.
Great. All right, Mr. Peoples, anything else in Mr. Huff's case?
Nothing further.
Ms. Wood?
No, Your Honor, thank you.
All right, thank you, everyone. All right, all I have left on the calendar, since Mr. Peck is not available, O'Neill was a plea. So we've got Mr. Dill. In theory, Mr. Lewis's 3 cases are pleading out tomorrow morning. Ms. Bumpus will be here. Mr. Lewis will get brought over. So we'll do that as part of our final plea. We've got 4 pleas from Mr. Kuntz.
One of the drug cases is going to be non-prosecuted.
We're resolving 4 cases for Mr. Kuntz. So then it's DeMonte Williams is the only other case left, and that still goes on our be ready for trial list.
We are very close to having a negotiated resolution, but I think we will fix that later today.
Okay.
Yeah.
Well, you tell me. So that means we're left with Kuntz and Williams. I'm happy to do one, and we take a quick break and then do the other. Or we can take a break if people need time for either one to be ready.
I do need to speak with who's just about to break down.
Okay.
So what is going to do, Mr. Williams, for me? Well,
As in, we can bring Mr. Williams out and do the plea. Let's do it. So not to put all our eggs in one basket, but that means Dill is what we're doing on Monday.
That is perfectly fine with me.
All right. Makes it easier for me to prepare too. So we're ready for DeMonte Williams, please. Oh, you guys crushed this calendar.
Yes.
I take all the credit, Judge.
Yeah. All parting gifts for Mr. Peoples.
Yes.
He has all this new stuff in his plea colloquy about this is your lawyer for the next 30 days. And is that for like the young bucks on the team?
Every
That's
courtroom is
gonna
so different.
make our plea colloquy longer. I may have to shave some of that off.
I'm assuming he picked that up from another courtroom because
I
he and
think
I
so.
we actually were together in Judge Glanville.
And
this is
that
the one
didn't
I had
happen.
him using. I don't know where that came.
Completely different ones in each courtroom.
It is. It's funny when people cover and I'm like, whoa, what are you doing? Like, hey, this is my colloquy. All right, each to her own. All right, Ms. Feely, are you ready?
Yes.
Okay. Mr. Williams, you ready to go forward?
Yes, sir. How are you doing?
I'm doing okay. How are you doing?
I'm fine.
All right. Orange jumpsuit. Does that mean you're in Cobb?
Yes, sir.
Okay. How are things in Cobb?
Everything good.
Glad to hear. Mr. Williams, you are positions 24 and 25 on this trial calendar. And Ms. Feely tells me that you have reached maybe a negotiated plea with the state. Either way, you're prepared to enter guilty pleas in the two cases. Ms. Willingham, who's the prosecutor, will be putting you under oath in just a moment. After that, she'll ask you a bunch of questions, which you'll need to answer truthfully and completely. It is important that if you have any questions, because you're curious or confused or whatever it is, that you let Ms. Feely or me know that you've got a question so we can answer them. Will you do that? Yes? Okay, you got to answer out loud.
Oh, yes, sir.
Okay, the third part's not important, but the yes or the no, that way the court reporter can take it all down, okay? All right, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, your age, and your date of birth.
Let's say Bernard Williams, 9/20/1991.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
Can you tell me how old you are? Ms. Williams, we were just talking about different colloquies, and she asked for date of birth. I'm like, that involves math. How old are you?
31.
31. Great. Thank you.
I'm not sure if I asked this, so I'll ask again. Are you now under the influence of any medicine, drugs, or alcohol?
Did take seizure medicine.
Is the medicine you have taken been prescribed by a doctor?
Yes.
Does it in any way inhibit your ability to understand the proceedings today?
It does.
The medicine that you're taking, does it leave you woozy or drowsy or confused?
It does. It's
When did you last take the medicine?
I didn't even take my medicine this morning because I had come like directly to court.
Okay, so you didn't get the medicine this morning. Does that mean that you are in some way anxious because you didn't get the seizure medicine, or are you doing okay?
Okay.
All right, and you mentioned that the medicine has a side effect of making you feel a little out of it, but you didn't have it this morning. Are you feeling a little out of it, or are you feeling focused? Focused, great.
How far did you go in school?
11th grade.
Can you read and write in the English language?
Yes.
Have you had an opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiation in as to 22 SC 185335, as to counts 1 through 3, the state would be null processing. And as to count 4, 12 months to serve, you would be sentenced to 12 months to serve. And in 22 SC 185336, which would run concurrent with 22 SC 185335, count 1 of that indictment would be 5 years to serve 1 year. Count 2 would be 5 years to serve 1 year, and both counts would run concurrent.
Yes,
Is that what was explained to you?
Yes.
yes,
You're pleading guilty today to willful obstruction of law enforcement with a minimum of 1 day and a maximum of 12 months, battery family violence with a minimum of 1 year and a maximum of 5 years, and aggravated stalking with a minimum of 1 year and a maximum of 10 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
no,
You heard me tell the court what the negotiation is as to both cases, which is a total of 5 years to serve 1 year with the balance on probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 16 years? I think that's
yes,
Is my math right, Judge?
No, it's
Okay.
correct. So all that means, Mr. Williams, is I understand there's a recommendation, and it's 5 years to serve 1 year, basically, across the two cases. And I will be very influenced by that, because the people who know more about the case are you and your lawyer and Ms. Willingham. But that doesn't dictate what I have to do. I may learn in hearing about this things about you that make me think, well, dang, that I don't think that's enough. I think it should be 5 years or 10 years. I'm the judge, I can do that. But the ceiling would be how many? What did you say? It's 11 years.
Okay, well, yeah, my math was way off.
Yeah, your math was way off. Well, I don't know. What's the range for aggravated stalking? Is it 10?
Yeah.
Okay, so it's 16 years. Yeah. So the maximum you could get would be the 12 months, which is 1 year for the obstruction in one case, and then 5 for family violence battery and 10 for aggravated stalking in the other. If you add that up, that gets you to 16. No one's saying that you're going to get 16, but that's the ceiling. There's a floor. The floor would be 0. Okay? Understand?
yes,
Okay.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence.
Hold on 1 second.
okay,
Okay.
You okay? Would it be better if you want to sit for the rest of this?
okay,
You okay? Okay.
Under the special conditions, you would be required to have no contact with the victim, complete family violence intervention program, and have no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
yes,
Are you entering your plea of guilty with an understanding of everything we just talked about?
yes,
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
yes, I guess, yes,
Anybody threaten you?
Hmm.
If you could answer that
Okay.
question one more time.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
And I want to be clear on the promises. It may well be that what Ms. Feely has relayed to you is that Ms. Willingham has promised she's going to recommend this or that. That type of promise is fine. The promise of, hey, I'll give you $1 million if you plead guilty, or a threat, you better plead guilty. I'm going to break your arm. I'm going to hurt your family. If there's been things like that, we need to talk about it. Basically, I need to be comfortable that you're entering these pleas voluntarily. You've had a chance to think about it, to talk about it with your lawyer, and Mr. Williams is deciding this is what I want to do. Not because someone's twisting your arm or saying, hey, just get through this. I need you to plead guilty because I really did it, but you plead guilty and I'm going to give you $10,000 when you get out of jail. That would be an interesting promise. It would be an illegal promise. And I should not accept your plea if that happens. Anything like that happen in this case?
no,
No? Have you decided that you want to go forward to resolve these two cases in the way that we are today, only after talking with Ms. Feely and being comfortable with that discussion?
Yes.
Okay.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
Really, no, I don't.
Okay. Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses and 12 months from the date the sentence is entered for the misdemeanor offense. Do you understand these time limits?
Yes. Yes.
Your Honor, should these cases proceed to trial, the state would prove beyond a reasonable doubt that in indictment ending in 85335, that on September 14th, 2022, at 835 Oglethorpe Avenue Southwest, Atlanta, Georgia, the defendant was on probation for battery family violence against Ms. Trotman, the victim in this case. The conditions of his probation prohibited him from having future contact with Ms. Trotman and from being at the address of the incident location. Trotman also stated that she had a TPO against the defendant. Trotman told officers that she got into an argument with Williams over a phone charger. And as Trotman was leaving for the day, when she placed the phone charger in her purse, Williams demanded that Trotman give her the phone charger, but Trotman insisted that it was hers and she needed it. Williams unsuccessfully tried reaching in her purse multiple times to take the charger. That's when Williams began to repeatedly strike Trotman in the face with a closed fist. Trotman stated that the two tussled around the floor for a few moments before she was able to escape to the bathroom. Once in the bathroom, she called 911. When she heard Williams leave the apartment, Trotman left the bathroom and locked the front door behind him. She left the bathroom and locked the front door behind Mr. Williams. Trotman looked out the window to make sure she saw Williams. She observed him standing outside with what appeared to be a handgun. Williams yelled loudly, "I'm going to shoot this hoe up." He then went back to the apartment and started banging on Trotman's door loudly. Williams fled on foot when he heard police sirens approaching the complex. As to indictment, I'm sorry, I need to finish that. During the investigation, an officer spotted a male who matched the description of Williams. After giving verbal commands to stop, Williams did not stop. This resulted in a short foot chase, which ended in Williams' arrest. Officers observed visual injuries on Trotman. She had a laceration, which was bleeding on her nose. And as to indictment ending in 85336, on June 25th, 2022, and my apologies, I should have read them in the reverse order. On June 25th, 2022, at 835 Oglethorpe Avenue, Southwest, Atlanta, Georgia, Williams was on probation for family violence against Trotman. The conditions of his probation prohibited him from future contact with Trotman and from being at the address of that incident location. On the day of the incident, a neighbor called the police because he heard yelling and observed Williams push Trotman. When officers arrived, Trotman told officers that they were arguing over rent money. A physical altercation started in the bedroom when Williams began striking Trotman in the face with a closed fist. The altercation carried out into the breezeway of the apartment where Trotman was pushed. Officers observed Trotman's busted and bloody lip. Trotman stated the abuse was ongoing. She specifically stated, "Every time he comes over, I get a new mark." go back to my notes, Your Honor, so I can relay my communication. Your Honor, it looks like I was never actually able to get this victim on the phone. She did speak with several of our victim advocates. In the last communication, she sent a text message stating she would call back. I did also send her a text message asking her to call me, and she texted me as well and said that she would call me. She said today, I attempted to call her because I did not actually get a call from her and did not hear back. I actually attempted to call her again on Monday at the number that I received the text from, and that number is now disconnected.
Okay.
Nothing further from the state.
Got it. And Ms. Troutman and Mr. Williams have a kid or kids, plural, together?
They were living together.
Okay, it lists in the indictment that Ms. Troutman is the parent of the child of the accused. So that may have been a pleading defect you had. And Ms. Feely can clear this up better. But your understanding is that they were boyfriend, girlfriend who cohabitated.
Yes, Your Honor, that's my understanding. And as I mentioned, I have not had an opportunity to speak directly with her. So it could be that they also share a child. And it's possible that the person who wrote the indictment was able to confirm that, but because I haven't been able to speak with her, I don't want to speak to that.
Understood. Okay. Before we get to you, Ms. Feely, let's get a little criminal history information, if there is any. Ms. Jackson?
He has 9 cycles. The last arrest was January the 28th, 2022 with the City of Atlanta Police Department for battery, family violence. He has 1 misdemeanor conviction. It was in 2017 for disorderly conduct. Nothing in addition, Your Honor.
Thank you. All right. Ms. Feely.
Thank you, Your Honor. As the court can imagine, this is one that I think would look very different than the state's proposed version of events at trial, particularly that would suppose that they got her here, which is very much in the air. However, Mr. Williams is ready to accept this, and we are asking the court to consider, instead of 1 year, 12 months reduced to time served. And we're also asking for a first offender. I need to share with you a little bit about Mr. Williams. He's 31. When he was 17, he was hit by a car, and this kind of changed the trajectory of his future for quite some time. He had to relearn a lot of things. He had a traumatic brain injury, which is the most long lasting of the problems that he's had. And he's very smart, but his processing, the court might have noticed, it takes some time for him to process what's being said and done around him before he can respond. He is able to work now. He was working at Popeyes on the West End. He does dishwashing and cooking. He doesn't have any family with him at this moment, but his sister was here earlier. His mom and his brother also always come. And the traumatic brain injury is what the seizures stem from. And he's had 2 seizures since being in jail. Last count. Okay. And that is, he has them fairly regularly, unfortunately. So he has some issues that I hope that he can get better treatment for outside of jail. And so we're asking the court to consider all of that. And hopefully we're asking for a 5 to 12 months reduced to the time he's been in, which has been since September 14th.
Okay. When you say that it would be a very different version of events, if you were able to present Mr. Williams' side, as we have heard now many times today and many times over many days, there's still, when the police show up, the alleged victim doesn't have alleged injuries, but has injuries, a busted lip, or this or that. What's an example of something that I would learn that would be, oh, you know, Ms. Troutman punched herself in the face?
I don't know that there are pictures. I think it's just on the body cam that you're alleged to have been able to see something. I've watched the body cam. She's mostly in the dark doorway.
Okay, when I say pictures, that it sounds like the law enforcement officer, the witnesses who they don't have a side to take in this. They show up, this woman's bleeding from the mouth, they arrest this guy. That seems like a more objective, here's what we found. Now, it doesn't explain the cause. It just says, in fact, there are injuries, as opposed to someone calling saying, oh, he nearly chopped my head off, and they show up and there's no evidence of any injuries, and there's not a giant knife with which one could chop a head off. What would be different? I'm focused more on the 336, where supposedly Ms. Troutman has the busted bleeding lip, and there's a stay away. You can't be around here because it's a condition of his probation. I understand that it's not going to trial. Some of that can be proved up without Ms. Troutman. If in fact Mr. Williams is found to be where Ms. Troutman was, and there is either a protective order or a condition of probation and whatnot. So I'm not disagreeing with you or arguing with you, other than I'm trying to understand how this is not kind of serious, because it's actually two different aggravated stalking cases. And I appreciate the state's null processing some of the counts, but I didn't really hear why. I meant to ask why. And if the answer is it's just how we negotiated it, then that says to me it might be hard to track Ms. Troutman down. It doesn't say to me that Mr. Williams isn't working through some issues that cause him to fairly routinely beat up someone he cares about. And that's the part I'm most worried about. I want him to do better and continue to recover from the traumatic brain injury. I also want him to not beat up his girlfriend.
Sure, and that would be a problem for us at trial, the fact that there is a body cam that allegedly shows some injuries to her. We don't have an explanation for how that injury occurred. As far as the aggravated stalking, I am just not sure he realized how serious that was, and that's on him. But after speaking with him and speaking to his family members, I don't think he realized how that was a felony that he was committing just by going there.
Okay, and my point wasn't serious or not serious as it was. He's violating this court directive, and it's usually pretty easy to prove. I don't know how much of it hinged on Ms. Troutman coming in here saying, I really am going to stick it to Mr. Williams, or being reluctant, or what. But we digress. You've helped me understand some of the things Mr. Williams has been working through. Was there more that you wanted to share?
That's just that we're asking for first offender treatment as well.
Okay. Mr. Williams, have you had a chance to talk with Ms. Feely about how first offender works?
Yes.
Okay, I'm going to talk to you about it a little bit. Before that, though, how old were you when the car accident happened?
I was 17.
Okay. Were you in a car, or you were a pedestrian and a car hit you?
No, I was on a bike. I was going to work.
You were on a bicycle. Okay. And a car hit you on the bike.
Yes.
Were you wearing a helmet?
No.
No. Okay. How long were you in the hospital?
Maybe 6 months.
Wow, that's a long time.
And another 8 months
What was the other 8 months?
in the hospital.
So for more than a year, if you add it all up.
Yeah.
Okay.
And that was rehabilitation, right?
Okay. All right. Well, you seem to be doing a lot better, which is good. I hope it keeps going that way. So first offender, Mr. Williams, is a way you can be sentenced if you've not been in trouble before. And you basically haven't been. I know you've been arrested a few times, but you don't have a felony conviction. And so you can say one time, hey, I'm not going to normally get in trouble. This was a strange situation. That's not me. And I'd like to be sentenced as a first offender. If you are, it's not a conviction. And if you successfully complete your sentence, it all sort of goes away, which helps with work or school or getting benefits, things like that. The risk you have is that if first offender doesn't go well, and whether it's Ms. Troutman or another young lady with whom you're involved, or a family member, you get angry and you put hands on them and you get arrested, I could revoke your first offender status and give you a pretty long sentence. So there's a risk if you aren't so sure you're going to be able to stay out of trouble, then first offender is not a great idea. If you're pretty sure that nothing like this is going to happen again, then first offender is a great idea. And of all the people in this room, you know best whether you are in a position to stay out of trouble like this, with the seizures you've got and the medication you're taking and what you're working through. If you're kind of, I don't know, I might get into it with another girlfriend and shove her down, something like that, that could get you into lots of trouble with this case that you've pled to. Do you understand that?
Yes, sir.
And do you think that first offender makes sense for you?
Yes.
And why is it that you think that something like what happened with Ms. Troutman, not once, but twice, isn't going to happen again?
Because only reason I'm not going back around her because she would disrespect my mom. So on my part, so that I walked away.
So you haven't been around Ms. Troutman for a while? Okay. Do you have any kids with Ms. Troutman?
I have a little boy,
You have a little boy?
but he's with his grandmother.
Okay. How many kids do you have?
I have I have twin sons, Jalen and Jordan. My two little girls. It's made 4.
So 4 kids?
Yes, sir.
And Ms. Troutman is the mom of one of those 4?
And she's the first one.
Okay, so a little girl.
No, my son.
older son? Yeah.
Is
Oh, I thought you had twin sons.
twin son is my son, twin son, mom named Yona.
How do you have twins with 2 different moms?
He has 5 kids total. He misspoke. He
Oh.
has 2 girls and 3 boys.
Okay,
And I believe the oldest one is 8.
Yeah, my
And the
oldest
twins
son.
turned 5 since we've known
Right.
each other.
so your oldest son is with Ms. Troutman.
No, my oldest son is he's 8. It's Noah.
Okay, Ms. Troutman is the mother of a boy or a girl,
Boy,
but not the twins.
not the twins.
Okay. And is that a son that you're going to still want to spend time with when you get out?
Right now, my son not with his mom. He's with his grandmother.
You mentioned that, but that's good because then you don't have to be around Ms. Troutman because he's with his grandma.
Right.
Your mom or her mom?
Her mom.
Her mom. Do you get along all right with Ms. Troutman's mom?
Yes, sir.
Okay. All right. Do you have any questions about any of the things we talked about?
Okay.
No?
No.
Okay. Well, Mr. Williams, let me go back to Ms. Willingham. Why did you no pros those counts in the 335 case?
Your Honor, you're correct. It is because Ms. Trotman is hard to track down and that we just felt that this was a resolution that we could reach.
Fair enough. State's call. All right, Mr. Williams, I find that there's a factual basis for your plea in both cases. The one from June of last year and the one from September of last year. I also find that your plea is knowing and voluntary. We've already talked about the voluntary. That's no one's forcing you to do this and no promises other than the state has promised to recommend what they recommended. And a knowing plea just means that you've either understood everything we've said, or if you didn't, you asked me or Ms. Feely about it. Do you feel like you've understood what we've talked about?
Yes, as long as I do my time, I'm out.
That's true. Once you do your time, you're out. Then you'll be on probation for a while. And you're going to need to do that as well with this first offender. You don't want to mess up on probation because first offender can make that a problem, right?
Right.
Okay. All right. I'll accept your plea. I am sentencing you under the Probation Options Management Act, which means only that while you're on probation, if you have a small problem on probation, you and probation will resolve that. But if it's a bigger problem, and by big, I mean you get arrested again, or you have contact with Ms. Troutman, something like that, that's going to be something that comes back to me. Okay.
Okay.
Mr. Williams, is it okay if I or someone who works with me signs the indictment for you saying that you're pleading guilty in the 2 cases?
Yes.
All right. Ms. Feely?
Yes, Your Honor.
And Ms. Willingham?
Yes, Your Honor.
All right, we'll do that. What I'm going to do in the case 22 SC 185335, which has only a misdemeanor left, count 4, I think.
Yes.
Yes, count 4, is I'm going to sentence you to 12 months to serve. You'll get credit for all the time you've been in, and that'll be that case. Case 22 SC 185336. which is the case about the June incident, busted lip. And Ms. Troutman told the police every time you come over, she gets a new mark. I'm sentencing you on count 1 to 5 years to serve 1 year with a balance probated, and the same sentence for count 2. And I'll run those concurrently with each other and concurrently with your sentence in the case ending in 335. I will sentence you as a first offender in both those cases, which are consolidated for the purposes of sentencing. So you're a first offender. And it means that your overall sentence is exactly what was negotiated. So it's 5 years to serve 1 year. You'll get credit for the time you served, and then you'll be on probation for 4 years. Special condition of probation number 1 is that you complete a family violence intervention program, which is a set of classes that is meant to help you handle conflict with people you care about in a way other than you have in the past. No pushing, shoving, hitting, that kind of stuff. And I want to structure it the right way with Ms. Troutman. I wrote down no contact, but she's the mother of his kid. And so I don't know if it is no unsupervised contact. I appreciate that their shared child is with Ms. Troutman's mother. I don't know if that's a forever solution.
Right.
So what do you suggest, Ms. Feely?
No violent contact.
Okay. No violent contact with Ms. Troutman. You may need to call her to, what's the name of the child that you have with Ms. Troutman?
Noah Troutman.
Noah?
Noah Troutman.
Noah. So you may need to call Ms. Troutman to say, hey, I'd like to see Noah. That's okay. But if you call her and then show up and throw your phone at her, that's not okay. No violent contact with Ms. Troutman. Don't yell at her. Don't fuss. Just say, I'm going to see Noah. And she says, I need diaper money. Here's some diaper money. And then walk away. It's just that's limited to you being able to spend time with Noah. Okay. Any questions about any of that?
One question. Like, cause I'm doing my 12 months, meaning as I'm like be able to get out.
So what I've got for you, Mr. Williams, let's look. You've been in 267 days at least. There may be more than that. And I've sentenced you to 1 year. So it's about 100 more days than that. Now, you'll get credit for all the time you've been in. And that's a small enough amount of time that the sheriff may say, I'm not going to send you down to Department of Corrections. I'm just going to get you out. So I don't know how to answer it other than to say, my sentence for you is 1 year, 12 months. And you've already done a whole bunch of that. And you'll get credit for all the time that you've been in. So it's not a year from today. It's a year from, it looks like you got arrested the second incident at Oglethorpe when there was supposedly this fight about the charger, the phone charger. You've been in jail since then. You get credit for all those days towards your year. Does that make sense?
So it's September the 14th, right?
That's what I just said. All right. You're going to need to answer a few questions from Ms. Tucson, who is with probation, who is going to need to just figure out where you're living when you get out. Okay. Ms. Tucson?
Hello, Mr. Williams.
How you
What
doing?
city, I'm doing good. How are you?
I'm doing fine.
What county do you live in?
You live in Fulton County.
When you get out, where are you going to go live?
Most likely Fulton.
Is it your mom's place? Is it your
My sister's place.
your sister's place? Okay.
Okay, do you have a address and phone number that I can have for your sister or your mom? That way I could contact them, give them your reporting instructions, your report here to Fulton County.
The address is 1111 Westview Drive, apartment 7, Atlanta, Georgia 30310. And my mother number is 404-484-3330.
404-484-3330.
Yes, ma'am.
And then you said 1111 Westwood?
Westview Drive.
Westview?
Yes, Westview Drive.
Okay, well, so I'm gonna let them know you'll need to report to Fulton County Probation since you'll be in there for a little while longer upon your release to report for probation, okay?
Yes.
And it's
ma'am.
around the corner from the courthouse at 276 Memorial Drive. But I will give this information to her.
Okay.
All right, Ms. Willingham, anything else in Mr. Williams's two cases?
Nothing further.
Ms. Feely?
Yeah, yeah.
All right, good luck, Mr. Williams.
All right, thank you, Judge.
You're welcome.
Judge, may I be excused?
Yeah, you have nothing to do with the Kuntz case?
I have nothing to do with that.
Go for it. Get out while you can. Do you need time to talk with Mr. Kuntz?
I think it will be smoother if I can speak with him just to make sure he knows what his counsel is doing.
All right, well, we will wrap things up in the online world now, if there's nothing left other than Mr. Kuntz.